flurry of activity with regard to Bennington's motion. I did, in fact, I only literally in the last hour, because yesterday was a holiday, the other Battle of Bennington day. And I only just got these because our clerk only just caught up with what was in her inbox. I just haven't gotten yet to file her paper. Both, I have in my hand the preemptive filing by Apple followed by Bennington's filing, followed by Apple supplemental filing. Are there any other materials related to Bennington's motion to intervene that I should have?
No, sir.
And you are?
I'm Brianna Collier. I'm with Witten, Wilmington, Kimball, and Bernal. We represent the town of Bennington.
Okay. Are you going to be the representative here?
Yes.
Why don't you go ahead and take a seat at the table?
Sure.
Do you have a card?
Yes.
Okay, great.
And Mr. Towsley, the department, like you, did not have an opportunity to review these until very recently, and therefore, you know, we would normally wait in with some responses, did not have an opportunity to do so.
Oops.
I'm not asking for an opportunity to do so now, I'm just letting you know there's nothing from us in that stack of comments.
Did you get these guys?
I did
Have you had an opportunity to look at them?
enough to discuss them today and to develop a position on behalf of the department. But not necessarily a legal response in terms of point for point on each of the cases, but a position.
Sure. Okay. Ms. Collier, do you have all these materials?
I have seen the most recent filing, which I think just came in an hour ago or so. Haven't had a chance to read it carefully.
Ms. Harris, do you have all these materials? There should be, there's 3 documents. 2 of them were delivered yesterday, 4 of them were delivered today.
Yes, I have them.
Okay. Have you had an opportunity to look at them?
Yes.
Because it's highly likely that we'll get on the record, this will be the first thing that we'll talk about. So what I foresee, at least initially, is a discussion of this motion. And then I will probably take a little break to consider the motion, and then come back down before we go any further, I think, with given the potential for whatever outcome arises in this discussion to alter the timing conceivably of the motion. And that leads me to a question, Ms. Collier. I don't see a request for more time.
No, we did not include that. I do have paper copies if anybody needs a copy of our motion. But really what we're after is the opportunity to participate going forward with the briefing and comments that are still in the schedule.
Oh, okay. Well, that's good to know, because that means we can do our hearing.
Yeah, absolutely. We've just recently been retained by the town on this matter, and, you know, we were not expecting to participate in questioning today. You know, I'm happy to argue the motion if you'd like to hear argument on that. Otherwise, I'm pretty much here to listen closely and look at the evidence and try to catch the town up to speed for going forward.
Okay. And you understand, you're not a regular player here in front of us, you understand the process as it will unfold in the next month or so? That is, that I will prepare a proposal for decision some point in the next month or so. And that proposal for decision will be delivered to all the parties for their comments. At that time, the parties can comment on that proposal for decision. And in that is a request, if you ask for it, to for oral argument before the board. think, okay. With that, then I'll get back to my regular checklist for a technical hearing.
Should we discuss how the town is going to be participating in the post-hearing process? Are we going to be as an intervener, as a friend of the court?
That depends on how I rule. And I can't tell you how I rule, because I don't know. But those are effective, there are three options. The first option is as another member of the public. It's not like here. My anticipation is that since they have sought to intervene, that they will want us to intervene, and an option in the face of an intervention motion is for the board to offer the opportunity for that individual or the body to serve as a friend of the court, which is something that the board doesn't do very often, but has done more often recently. But those would be that effectively what the friend of the court affords, and we talked about that with Mr. Carroll last time we were together, is it affords the individual, should the board determine, which you have to ask to be a friend of the court, and the board has to grant you that status, that you will have the opportunity to brief just as a friend of the court in a civil or in a civil judicial matter would have that opportunity, including, and the board would opine or would use whatever materials that were provided by a friend of the court to shape the board's opinion in the same way as would happen at the Supreme Court. I'm not sure what the status would be, and I'm not sure it's appropriate for me to attempt to address that right now.
Mr. Townsend, just a clarification question. My recollection of the schedules that we have so far just take us basically to technical hearing. So were you contemplating parties file their own draft P4D with briefing, and then the board, the hearing officer would issue one, and comments on the P4D after that in the usual course?
Yes.
Is that how you, okay.
Yeah, that's one of the things we can talk about now. Since you brought it up, we'll do that.
Okay.
The first thing to find out is whether or not we need to get to the motion first, because it doesn't appear that anything seems to delay per se in the process. So, which means we'll move forward with today, which means we can establish our schedule for the remainder of the proceeding. Have the parties had an opportunity to talk amongst themselves about a potential schedule?
We have not yet. I think what we did with Chelsea was it was based on getting the transcript back.
Okay, I think what I'd like to do is go on the record and address Bennington's motion, and then take a break for 15 or 20 minutes or so. During this time, I'd encourage the parties to attempt as much as possible to develop a schedule that you could propose when I got back.
What, excuse me, when would the transcript be ready?
when it's
Practical.
done. That's not something that I have any control over. I'm not sure. 2 weeks. Okay, I think with that, I'll go ahead and go on the record and deal with the motion that's before me. Good afternoon, I'm Mike Towsley, with me is Dave Watts, also on the board staff. I am serving as the hearing officer for the Public Service Board in this matter, which is a petition of Apple Hill Solar LLC for a certificate of public good pursuant to 30 VSA Section 248, authorizing the installation and operation of a 2-megawatt solar electric generation facility at 1133 Willow Road, Bennington, Vermont. The board docket number is 8454 for this case. We are together today in the board hearing room in Montpelier to conduct a technical hearing. First, I'd like to take appearances. So if you could state your name and affiliation with this matter, then I'll summarize the off-the-record discussion we just concluded.
Jeannie Elias from the Department of Public Service, and with me today are the department's engineer, Ellen St. Peter, and the department's aesthetic consultant, Jean Misery.
Don Einhorn for the Natural Resources Agency.
Libby Harris, who am representing myself pro se, and Rick Carroll, who is my witness, and Annette Smith, who's my consultant.
Brianna Collier with Witten, Williamson, Campbell, and Bernal for the town of Bennington.
Michael Malone for Apple Hill Solar. With me today, I have Brad Wilson, who's the project manager for Apple Hill Solar. We have Mark Kane from SE Group, who's our aesthetics consultant. And Scott Michael Mapes is one of our environmental consultants.
Okay, we did have a brief discussion off the record prior to coming on the record, at which we discussed the motion materials I have in front of me, which were delivered yesterday and today. There is a preemptive discussion from Apple Hill Solar dated yesterday, that was delivered by email yesterday, as well as a motion of the town of Bennington, which was delivered by email yesterday, and Apple Hill Solar's supplementary memorandum in opposition to that intervention, which was delivered by email today. I note by email because, generally speaking, filings only occur with the board when they are done in paper form. Given the timing and nature of this, and we get it today, I'm going to rely upon these. It's my understanding that all parties have copies of these materials. I think they are relatively comprehensive. What I would like to hear from the parties, all the parties, as to their responses to the motion by Bennington to intervene as a matter of right in this proceeding as a municipality. And I think what I'd like to do with that is I don't want to hear a regurgitation of what's in the written materials. So this isn't an appellate argument. council. This is just if there are key points that you would like me to remember as I go upstairs and consider the motion. I'd like those reiterated. I'm very interested in what the department and Ms. Harris think about this as well. I know what the town of Bennington and Solar's positions are. So, Ms. Elias, are you prepared to talk to this?
Yes, as I said in our off-the-record discussion, I didn't have a great deal of time to consider it or to do research or write a legal response. The department's ultimate position is that we believe the town should be granted intervenor status based on the fact that the board always has the discretion to grant intervention. It's, I don't think it is necessary to put a lot of thought into whether it's permissive intervention or intervention of right at this point in time. Because the town's motion seeks only to brief the matters after the hearing, it would be, in the department's view, no prejudice to the petitioner or to any party to have their briefing. There won't be any delay, and that's as far as our argument goes, and I think that obviates the need to look into the specific legal points made about whether Act 56 applies to this proceeding, about whether intervention is procedural, about whether other Vermont statutes are in conflict.
Oh, I understand. Thank you. Mr. Einhorn, I didn't refer to you. I didn't know if you had an opinion or something.
The agency takes no position.
Ms. Harris, do you have a position in this matter?
I can only speak as a citizen, not legally.
Sir?
I'm actually delighted that the town will seek to intervene because I feel that my intervenor status was granted for circumspect issues, and now that the town is looking at larger issues and how it will impact the entire town of Bennington rather than just my personal perspective, I welcome the town very much.
I think now, Ms. Collier, I think I'd like you to provide me with a brief summary of your motion.
Absolutely. We do believe that the town should be granted party status as a matter of right, and in the board's discretion to always grant, always be able to grant intervention party status. We would like for the town to for the board to recognize the town as well. This is a very public area with a highway interchange. There's a lot of visibility, a lot of impact to the town as a whole, the public interest of the town, and we'd like to be a part of the proceedings going forward. As you mentioned, you don't want a regurgitation, but we do believe that the statutes and the case law supports our position, and we hope the town will grant us party status today.
You have, what I'm looking at on page 4 of the brief indicates this alternative request was based on the town's substantial interest in potential aesthetics, visual, and environmental impacts of the project. Can I understand from that that those are the substantial interests of the town?
They are, and I would ask to include safety as well in that list.
So the board, the town is seeking intervention and will want to address 4 criteria in 248 aesthetics. 3 aesthetics being visual, the environmental criterion broadly, and public health and safety concerns.
Yes.
So, and you've indicated indicated during the motion indicates that you don't attempt, that you're not seeking to alter the schedule of the proceeding. You simply wish, the town wishes the opportunity to comment first on the draft proposal for decision, and otherwise provide comment on the remainder of the process.
Correct. If there is an opportunity to provide a brief going forward, we would like to have the opportunity.
That would be part of it.
And if the town is willing to consider our input today, we would be happy to think about questions we might want to pose. But otherwise, as I said before in our off-record discussion, we're really mostly here to listen and gather the evidence.
Thank you. Mr. Malone?
Sure, and I'll try to keep it brief. I first contacted the town in October 2013, which is almost 2 years ago, so timing is obviously a little bit suspect here. The town seems to be relying on the argument for intervention as of right pursuant to the recently enacted Section 28 of Act 56. That particular provision doesn't exist in a bubble. You have to take into account 1 VSA 214(b)(4), which among other things prohibits amendments to laws which retroactively affect proceedings. There's also a Supreme Court case that it's in Raid Times versus Seasons from 2011, where the Vermont Supreme Court said that a permit applicant gains a vested right in the governing laws and regulations in existence when a complete permit application is filed. So I think that the petitioner
So is
here...
it your position that altering, that allowing the intervention of the town impacts the substantive rights of applicants?
It would certainly affect the procedural nature of this docket, to have another party.
Recognizing that they don't seek to change that.
To seek to change
The schedule.
the schedule, correct, but to have another brief adds to the just amount of work that all of the parties, not just the petitioner, has to respond to. I think if you're going to allow them to intervene, it has to be under Board Rule 2209, as if they were any other member of the public, like you did when Ms. Harris filed her motion to intervene, and I think just based on timing, I don't think it should be allowed.
I just wanted to add that the department would not object to the town having the right to cross-examine at today's hearing, which was among the comments that town council made. If granted intervener status,
Okay.
they take the case as they find it, and they would be entitled to cross-examination of witnesses.
Okay. Let's see where we go. It's now 5 minutes to 3. I think I want to take a break until 15 minutes after the hour, and then we'll start back up. I want to encourage you all to work together on a schedule in that time period. When we get back, we'll start off the record and talk about that schedule, and then come back on the record and do the remainder of the pre-hearing organization that I deferred in our earlier discussion off the record, and then we'll get on the record with the hearing itself. Are there any questions?
None for the department.
No.
No.
Great, thank you. We are in recess. Can the folks in the back hear me now? is Mike Townsley. We're back on the record again. I'm prepared to rule. My ruling echoes the comments of the department. Having only just received the motion and written responses, I have not been afforded the opportunity to address the law related to Section 248A4F as discussed in those papers. However, it is important that I do make a ruling now before we begin today's technical hearing. Therefore, I will rely upon my authority to permissively grant the town of Bennington party status based on its substantial interest in aesthetics, the environmental criterion, and public health and safety. I would also note that the board is a quasi-judicial body, which means that it isn't a court, but is instead a policy-making organ of the government. The enactment of 248A4F is a reflection of the legislature's public policy concern that municipalities play a role in citing decisions the board makes under Section 248. As Bennington has stated, it does not seek to alter the schedule by its intervention. Therefore, its intervention is permissively granted, taking the case as it is, pursuant to Board Rule 2.209, limited to aesthetics, environmental, and public health and safety criteria. Are there any questions? Sir?
I have a question regarding the scope. If they're taking the docket as is, the way that issues are normally handled are through pre-filed testimony, not through briefing, and public health and safety has not been an issue in this docket. So I request that the scope of their intervention be limited to aesthetics and environment.
Well, it's an issue that the board has to consider. It may not have been an issue of controversy thus far between the parties, but it is an issue, recognizing that the town of Bennington taking the case as is will have no opportunity to present new evidence of its own. Does that make sense? Do you understand, Ms. Collier?
Yes.
Are there any other questions? No?
Yeah.
Okay. Having made that ruling, I'm going to go back off the record again and talk about the stuff that I usually talk about before I come on the record. So today's witnesses are, as I understand it, Mr. Wilson, Mr. Mapes, or Mr. Kane, and Mr. Mapes. Do they have any timing concerns? Is there a reason I want to take one of them before the other? We also have Mr. Carroll, but we'll want to talk about him separately. Because there was a motion for Mr. Carroll to be excluded as a non-expert that we need to address, and we will do that first, once we get back on the record again. Are there any other witnesses or potential witnesses? Are there any changes or corrections to the testimony or exhibits? Have they been marked? Okay, great. How much time will you want, Mr. Malone, for your direct examination of Mr. Wilson, Mr. Kane, Mr. Mapes?
For direct, I don't expect more than 5 minutes each.
And how much time do the other parties anticipate seeking to cross-examine Mr. Wilson, Mr. Kane, and Mr. Mapes? How much time are you going to need if you're cross-examining? Do the parties intend to cross-examine these witnesses?
Yes, I have questions for Mr. Kane and for Mr. Wilson.
Okay, how long do you think those questions are going to take?
On the outside, an hour, probably
Each?
less. No.
For both? Okay. Did the other parties have questions for any of the petitioner's witnesses?
The department does not have cross-examination questions.
Okay.
Neither does the agency, but we would reserve the right to ask any follow-up questions.
Okay. I know we talked a little bit about this earlier, Ms. Collier, but do you have any anticipated questions on cross-examination, or are you going to just let them arise?
I don't have any prepared questions, but I would like to reserve the right to ask if
Okay.
that's okay.
It is a nice air-conditioned room. I don't want to go outside now, so. If I know that it's at least 90 in my house right now. Okay, Mr. Carroll, with regard to Mr. Carroll, how long do you anticipate Ms. Harris, his direct examination would take? Do you anticipate questions beyond just the entrance into evidence of his pre-filed testimony?
No.
Okay, so you're saying 5 minutes or thereabouts. And I think what I'd like to do, given your motion that will not be considered, is provide Apple Hill with the opportunity to voir dire the witness, to provide on the record additional, some evidence to support your motion, and for me to consider when making the determination as to whether or not. It's my understanding that what you seek to do is have his testimony not be considered because he's not an expert.
That's correct.
Okay. How much time do you want to, I know I just tossed that at you. How much time do you think you want to voir dire the witness?
I think 30 minutes should be sufficient.
And if, well, however I rule, I may allow some of his testimony or the nature, I may limit the scope of his testimony based on the degree of expertise that he has. As I understand it, there are 3 areas that he sought to be declared an expert in. One is aesthetics, wind, and noise. Is that correct? Those are the areas of testimony.
Yes.
Primarily, and you want him treated as an expert for those areas. It may be, and I haven't decided yet, but it may be that I'll only allow 1, or I may allow all 3. If it were all 3, if I fully recognize his expertise as stated in the documents that he filed, how much time would you like for his cross-examination?
I think another half hour.
I'm gonna hold you to that. And if we do direct exam, if we will do cross-examination of Wilson and Kane, so and that would be Ms. Harris. The way we would, and potentially the reserve right of the agency and the town, I think that what I would do is, unless the department has a question that they just can't not ask, we would go to the agency and the town after Ms. Harris asks her cross-examination questions of Mr. Wilson and Mr. Kane. Does that make sense? And if Mr. Carroll is permitted the opportunity to serve as a witness in this case, I've already mentioned this to Mr. Malone, do the other parties have any interest in cross-examining Mr. Harris?
No, the department.
No.
Mr. Carroll, I'm sorry.
Again,
You would reserve
I'd like
your
to
right?
reserve, yeah,
Okay.
thank you.
Do all the parties have all the exhibits?
I probably don't. One exhibit I would like to have that's on the list that Mr. Malone passed out earlier, this afternoon is the, plant inventory.
So, Rob, do you have another copy on this?
Yes. Ms. Colley, just to confirm, you're looking for Exhibit A, HS, SUP2, MK2?
Yes.
Four pages.
Thank you. Could I also ask for the discovery responses to A&R's first round of discovery?
Mr. Malone, while you're poking around in it, if you could find that other copy of your list of potential exhibits, I'd appreciate it.
Yeah.
So I know what you're talking about. Is there a list? That's good, you should keep it. Please, just so I can predict what's gonna happen and I know what you're talking about when you refer to it. I've also been informed by our avid video watchers that when you talk into the thing, we are being broadcast, and you can only be heard when you broadcast if the little green light is on in front of you. I'm not going to hold that rigid, but I would ask that if you think about it, to push the button, just so that if anybody is watching, they can hear what you're saying.
I do want to get Dory Barton's exhibits on the record.
Okay,
So-
you've already furnished an affidavit, as I recall?
Correct.
Okay. So why don't we do her first, just to get that done before we move to live witnesses. Okay. Ms. Harris, did you have a potential exhibit that you were talking with the court reporter about?
I had to have a notary sign this affidavit, and that was for the discovery. And I have the hard copy here, so I was trying to submit it.
Whose affidavit is it?
It's my affidavit.
Oh, to cover, so you want to put your pre-filed testimony into evidence using the affidavit as a supporting document?
Right, I sent it in, but in my discovery, but I was asked to have a notarized affidavit with my name on it certifying that it was me who was submitting the discovery, so I brought the hard copy today.
But these were discovery answers that you provided?
Yes.
Okay, so that's your attestation of the truth of the materials that you provided?
Yes.
Okay. Is there any objection to that being put in evidence?
No?
Nope. Okay.
I did want to ask the board to poll the parties on potentially taking the witnesses out of order, given the lateness of the hour. I have Ms. Vissering here to consult with the department when the testimony of Mr. Kane and potentially the testimony of Mr. Carroll are.
Okay. Mr. Malone, do you have any problem having Mr. Kane go first? I don't think Mr. Kane has a problem with
My house is air conditioned.
that.
Thank you.
I have a heat pump in my house, but I don't turn it on all the time. And it works great. Does both, yes.
I'm not sure this needs to be in the record. I think this is a filing that belongs with the board, a sort of subsequent filing, unless.
Okay, yeah, the others aren't really with the, yes, they aren't attached to,
Well, has some party included the responses to discovery? Has the petitioner included? Okay, so then it doesn't, I'm sorry.
okay. Were there any other documents, Ms. Collier, that you didn't have that you'd like to have?
I am trying to ascertain if I have the other discovery responses with me, which are from the department's filed, department's first round of discovery, petitioner's responses to departments, and I don't see them, so if you do have a copy of those, I would appreciate those as well.
Put on the witness stand, if you would put on the witness stand, but you're first going to just do
Department, but
quiz
these
to
look
make
the same as these, and these are supposed to be A&R. So you have a second.
Okay. Why don't
Are
you
you saying
go
you
back to
just
her?
take your copy out there?
And have her off.
Listen to the questions, discuss the question, take a break.
I thought one set just had a 1, 2, 3, and one set had a 1A, 1B. I only seen the 1A, 1B set.
So I'd like to
Oh,
offer.
when we get on a record, when we get around to your presentation of evidence, then we'll do that.
Okay,
And really, all you gotta do is say, I have what's been marked as, whatever it's been marked as.
okay,
I'd like to enter this into evidence, and I'll say, is there any objection? Everybody will say no, probably, and then it'll be in evidence.
okay. Thank you.
Yep, thanks.
You're going to be asking her first, and then that's going to be
I believe I have a complete set of paper exhibits with me now. If after the hearing I'm missing something, I could ask the clerk to send it on if that's fine with the board.
Yes, or if Ms. Elias could help you out, too. She may have them more readily available. Mrs. Hudson's out, which means they're shorthanded upstairs, which makes it slower.
Okay,
So it might be faster to than Ms. Elias.
okay, thank you. Yeah, thank you.
Mr. Malone, for your exhibits, do you have copies for yourself and your witness?
I don't have all of them.
Just to the extent that, well, there may be cross-examination questions that will require an element into it too.
I have a duplicate of this one now, so I can give you this back if that's helpful.
It's a little more complete.
We'll wait till Ms. Harris comes back to the room. Were there other matters that the parties wanted to talk about before, in her absence, that I need to know about? I think what we're gonna do now is go on the record, and we're gonna start off, I think, first with resolving the issue, a motion of Apple Hill to exclude the testimony of Richard Carroll. And in order to do that, I think what I'd like to do is ask Mr. Malone to voir dire the witness as to the reliability and relevancy of his testimony in the areas of aesthetics, wind, and noise, which I believe are the areas that you've sought, that he provided testimony, pre-filed testimony to, and which you argue he's not expert in. Is there any question? Once we conclude that, I will probably take a short break while here. We can take a break, take a little recess, and then we'll come back on the record, and we'll begin with Mr. Kane, so that Ms. Fisher doesn't have to spend too much time here. And then we'll go, if there's no objection, and then we'll go to Mr. Wilson, Mr. Mapes, and then potentially Mr. Carroll, depending upon how I rule with regard to the motion by Apple Hill. Is there any question? Okay. Let's go ahead and come back on the record again. We just had extended discussion off the record about actually, let's go back off the record, because one thing I did forget, and that was schedule. Were you all able to come up with a working schedule?
It's September 10th for the briefs, and September 17th for the reply briefs.
Did you install a date for your submission of the draft proposal for decision?
That we did not. Jeannie, would 17th work?
We want to see all the briefs first.
Yeah, it's gonna have to be later, because I'm gonna be out the week of the 14th through the 8th.
When do you return? The 21st?
Yeah.
The end of that week?
Oh, yeah, that'd be fine.
The 25th? Maybe does that work for you?
What, I'm sorry, what are you asking me exactly for the 25th?
So we have, a few weeks back, I sent you a draft of the proposal for decision. It's a very long document. It kind of summarizes the testimony of the parties.
I don't remember.
You'll comment on it afterwards.
Yeah, you reserve your right to comment on it.
Okay, I'll wait until the hearing officer issues a decision, I believe, and then I'll comment on it.
Okay, so you don't want to...
I'm so bad at this language, so.
Understood. So I think the 25th, she's going to reserve the right to comment on it.
Sure. As I would, there's no need to reserve that right. I mean, the draft proposal for decision is just it's a tool that's submitted by the petitioner to assist the hearing officer in crafting that my proposal for decision to the board. It's not a substantive document per se. The substantive is the final proposal for decision that I issue, that you get to comment on.
Thank you.
I understood from the MOUs that A&R and the agency and the department will likely not need to comment on that, so it would just be the town and Ms. Harris that would comment.
Provided it's consistent on material aspects, yes.
We'll have all that list of environmental things that I'll try to make sure they get in there, yes. Okay. So that was September 25th. Okay, thank you.
And just so Mr. Carroll is prepared, I had sent a list of discovery questions to Ms. Harris. She provided some responses, most of which I think were prepared by Mr. Carroll. Some of them were non-responsive. That's going to be the substance of my questioning to him, just so he knows.
Okay, just so you know that what I'm interested in is information as to whether or not his testimony is reliable and relevant, and otherwise based on his expertise and experience.
Yeah.
So part of that is, so how many times did you clear pieces of land such that you could develop that opinion? That kind of stuff. So if that makes sense. Any other questions, I'm sorry, before we go back into it? Okay. Now we're back. Okay, we just had a discussion of several matters, including schedule, and I'll start with that first because it's immediately in front of me. The parties have agreed upon the following schedule. September 10th would be briefs, September 17th, reply briefs, and on September 25th, the petitioner will file a draft proposal for decision with the board. Now, we're going to go ahead and begin the public hearing with a addressing of Apple Hill's motion to exclude the testimony of Richard Carroll. To facilitate that, I'm going to ask that Mr. Carroll come to the stand. Good afternoon, Mr. Carroll.
Good afternoon.
Do you swear or affirm that, on the penalty of perjury, that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Could you state your name for the record
My name is Richard Carroll,
and spell your last name?
C-A-R-R-O-L-L.
Thank you. And where do you live?
I live at 150 Apple Hill Road.
And where are you employed?
So I'm self-employed
As to what?
contractor.
And what do you contract for?
Building homes, additions, remodeling,
In the Bennington
in
area?
the Bennington area.
Now, Mr. Lamont, I'm going to ask that you, he's your witness to voir dire related to your motion.
Sure. Good afternoon, Mr. Carroll. You mentioned that you're self-employed. How long have you been self-employed? Prior to self-employment, were there any other jobs that you held for a company or otherwise?
I've been self-employed for 32 years or so. Before that, I worked actually, started a redemption center in Bennington.
Based on your responses in the discovery questions to Ms. Harris, it didn't appear that you held any specialized degrees, whether it be in wind or noise or aesthetics. Can you please confirm that that's the case?
I do not hold any specialized degrees.
And can you please state your formal education starting with high school?
I graduated from high school in 1975.
And you did not attend college or any graduate programs?
No.
In several of the responses to the discovery questions, when asked about specific scientific theories that you were relying on in forming the basis of your testimony regarding wind, aesthetics, and noise, you mentioned your experience living in the neighborhood. Am I to understand that there are no scientific theories behind your answers in the discovery question?
You know, it's based on factual things that happen in Apple Hill.
Going to specifically reference discovery question 58, which is a question regarding wind speeds around the project. And the question is, are there currently any measurable differences between the wind speeds at the Vermont Vulcan Center and at Mrs. Harris's house, Ms. Harris's house?
That's where the wind study should have been done.
So is your answer, you don't know?
No, unless the wind study is done, would you know that?
A lot of the responses to the discovery questions indicate that there's an existing buffer of trees that are protecting Ms. Harris's home from wind and from noise. Can you please explain how this buffer works?
The wind in that particular area comes from the welcoming center, which is from the west, and it goes up through Apple Hill.
As an expert in wind, have you performed any studies, wind studies specifically, for the project area?
I haven't performed any wind studies, no.
And what about noise studies?
Yes, noise studies.
And can you explain the noise study that you conducted?
We conducted decibel studies from Libby Harris's house.
And using what instrument?
It was Libby's iPad.
And you both did this together?
Together on the deck.
Mr. Carroll, this morning you were quoted in the Bennington Banner regarding the Bennington Select Board meeting that occurred last Thursday, August 13th, in which you were in attendance. And there was specific mention to a certain exhibit that's been filed in this docket, which indicates vegetative screening. One slide shows vegetative screening, one slide shows no screening. The only simulation shown during that select meeting was one showing no vegetative screening. You're quoted as saying, you showed the only simulation you were provided. Was it you who provided that slide to the town of Bennington Select Board?
That was the only simulation that I received to present to anybody.
And who did you receive that simulation from?
Libby Harris.
Have you read the testimony in this document?
I have read all the testimony that was provided me.
And as part of the testimony that was provided to you by Ms. Harris, did it include the supplemental pre-filed testimony of Mark King, which is our aesthetics expert?
No.
So the one slide that was shown at the Bennington Town Board meeting was taken from that supplemental testimony of Mark King. Is that the only simulation that you saw from that supplemental testimony?
Yes.
And as an expert witness in this case, do you think it would be necessary to read the entirety of the testimony provided in this case?
It was never provided to me.
Now, I'm going to refer back to the discovery questions provided to Ms. Harris, which she prepared. Question number 71 in particular, you state that the noise level has increased tenfold since the Welcome Center opened up. We asked you to provide some data in support of such statement, but nothing was provided. Can you provide some basis or some explanation as to how that noise has increased by tenfold?
Well, tenfold is a figure of speech. It's increased greatly because once the Welcoming Center was completed, that's where cars and trucks leave from. And when they leave and they go north, that's where they accelerate up the steep hill. So the noise that generated from the trucks increased dramatically. Also, when trucks come down and they want to stop at the Welcoming Center, is where they use their Jake brakes, and noise has increased.
And your expertise in, going back to wind for a moment, your expertise in wind, it's developed from your experience as a contractor?
Yes.
And have you done building outside of Bennington?
Manchester.
So is your knowledge of wind based on your experience in Bennington and Manchester?
Based primarily in Apple Hill.
And is it the same for wind or noise rather?
Yes.
Did you have any professional experience in measuring characteristics of sound and noise, other than the experiment?
No.
And what about any professional experience in measuring the effects of wind?
Personally, no. I do clearly understand the effects of wind in Apple Hill.
No further questions.
And I have a few, Mr. Carroll. How long have you lived at Apple Hill?
I've been there 20 years.
How many properties have been clear-cut since you lived there?
Just the property on the side of me.
Okay, so there was that one property.
Right.
What did you observe?
When the property next to me was clear cut. When it was clear cut, the winds came within months after that and just took out my tall pine trees.
Okay, have you observed that effect? Have you observed any other clear cut anywhere else?
The effects of clear cut,
Yes.
sure, yes.
Where?
I have in the West End where I work, I take care of 400 acres. It wasn't clear cut, but it was logged.
Okay. And how long did you work there?
I built a house in the West End 10 years ago.
Okay, how many acres of clear cut have you observed there?
logging was done on probably 5, I'm guessing.
So when you talk about logging, is that like everything goes out or just some logs? Some
Well,
trees
it's, a lot of the trees come out, I mean, but it's not stripped and clear cut.
go out? How far is the west end from Apple Hill?
Oh, it's on the other side of town, probably 5 miles.
Okay. But in Bennington?
In that.
What was the tool that you used on Ms. Harris's iPad to determine the sound decibel levels on the porch?
It was an app.
Do you know which one?
No, that's something that Woody did.
Did you, okay. In your testimony, you talk about your experience with aesthetics. And that makes you, precisely what is your experience that makes you an aesthetics expert?
Well, I set a lot of homes, I've set a lot of sites, I've done clearing in Apple Hill, I've cleared.
When you say you set a lot of homes and you set a lot of sites, what does that mean?
It means I'll go into a wooded area and selectively cut on whatever is designed to build a house. And what you do is you leave trees and you position the house and you set it. And in Apple Hill was the first one I didn't have, it was mine.
So when you talk about that and aesthetics expertise, is it your notion that that experience has shown you what kind of trees and shrubs and stuff to leave and what kind can go?
Right, and what looks nice, what fits in, how the driveway fits in.
So based on that, over what period of time have you engaged in that activity such that you know that experience?
I've been doing that experience for 20 years.
Okay, so you have 20 years of experience of setting homes.
Right.
How many homes did you do?
Probably a dozen, maybe.
Questions in line of my questions, Mr. McClure?
No.
From any of the other parties have any more questions for Mr. Carroll with regard to his testimony?
No.
No.
I do.
Okay.
When Velco Electric came through the community and clear-cut all of the trees, were you part of the process of rectifying that?
I was involved with many people to replan and look at what we could do to minimize the wind effect and the aesthetics of it.
And how different were the wind patterns before and after they clear-cut through the community?
Well, when it was clear cut, and they literally clear cut it, it was stripped. And when you have it, it's a 250-foot swath that goes right through Apple Hill. And once they did that, you could visually see and feel, especially when people walk their dogs and their pets, and you could visually see the snow in the wintertime just hold right to the ground. And everybody felt that. So over years, we negotiated and put in $5,000 worth of trees to try to minimize that. But the other thing is it grows in. I mean, it's never going to be like it was, but plants and trees, we planted some apple trees to buffer them in. And that's how we fixed it.
When did that occur, Mr. Carroll?
That was 5 years ago, I'm guessing, 4 or 5 years ago.
And you said it was, Velco came through and they did a 250-foot wide swath through the community.
Yes, and different, you know, plus and minus.
How far from the site of the proposed project was that?
2,000 feet.
So very proximate, within a couple miles.
Oh, yeah.
No questions for Mr. Carroll? Okay, you may stand down for now, sir. Thank you. And I think what I'd like to do now is provide Mr. Malone with an opportunity to briefly summarize his motion and for any other parties to respond to it briefly.
I think it sets an incredibly dangerous precedent to allow Mr. Carroll as an expert witness on any of these topics, whether it be wind, aesthetics, or noise. He's got no formal education in these areas of expertise.
Is formal education required, sir?
No, formal education would be one of several factors to consider.
Okay, so as he called it, his empirical experience is a factor that can be considered
His
in
experience.
determining whether or not he's an expert.
No, I don't think that knowledge of a specific area would make one person an expert in the field.
Okay?
So the precedent is concerning.
Is his testimony reliable and relevant?
Reliability, I think, is an issue given what occurred this past Thursday at the Bennington Select Board, where one of several slides that are included in Mark Kane's testimony was used to the exclusion of others. Specifically, there's two.
I understand. So your argument is that he's only going to tell us what he wants to tell us and not everything.
And I think there was a misrepresentation on his part at that meeting,
Okay.
saying that we were unwilling to.
So his
provide-
credibility is an issue for you.
Correct. And also, he hasn't read the testimony. And I think that's very telling that an expert would go on the record saying.
Ms. Harris?
Let me talk to the second issue first, which is the lack of proper information. For weeks and weeks, I was trying to get files, and I repeatedly asked Jeannie Elias and Susan Hudson to forward me a complete structure of files. The only time I got that was when I got into Venus Status to begin with, and Susan Hudson forwarded me all of the filings together. So the second testimony of Mark Kane, I didn't have, only belatedly got one simulation at the end. And so I take responsibility for not having everything that Mr. Carroll needed, but frankly, I found it daunting and overwhelming to try to get everything in one place so that I would know what was what. It's really, really difficult when you're not used to these circumstances to wrap your mind around everything and try to behave in an educated, intelligent way. So that talks to the difficulty in getting files and Mr. Carroll not being properly prepared for and only showed the one simulation to the select board. The other part which I'd like to talk to is this insistence on the 88 questions that you sent for discovery mostly had to do with what degrees do you have, what organizations are you with, what honors have you been given, what scientific theory do you base this? What scientific theory do you base that? And I maintain that 25 years of experience, 25 years ago, Mr. Carroll was looking to buy the very land that you bought to build Chelsea Solar, and walked every single foot of that land and knows it inside out. He's been a resident of our neighborhood for 20 years, has worked as a contractor in our neighborhood, has corrected situations on his own land and through the clear cutting of Velco in helping the community to restore itself. And during several major windstorms, he has helped residents of Apple Hill to restore their property to as best as they could be. So I think reliable and relevant and experience counts as much as any holding of any degree. And I ask you, do you need a degree in meteorology to know that it's raining outside?
Any other parties have comments?
None from the department.
No. I will. I'm prepared to rule. I'm going to deny your motion broadly, but limit Mr. Carroll's testimony to those areas within which I believe he does have some expertise as defined by Rule 702 of the Vermont Rules of Evidence. That is his experience with wind and its impact at the Apple Hill area, noise and its impact at the Apple Hill area, and the value and use of trees and other vegetative matter in siting properties at the Apple Hill area when setting new development in that area. That being said, your ability to opine on other areas beyond those is foreclosed. You can't talk about other stuff. The parties understand my ruling.
Yes.
Mr. Malone?
I guess I am going to have an opportunity to cross-examine with.
Yes, you will.
regarding- Okay.
So in developing the questions related to Mr. Carroll, they should be limited to just those things. That is his experience, which does not include whatever it was you did with your iPad, because there was no basis that was provided for the scientific value of that. That was one where you had some numbers. You didn't say what those numbers came from. He doesn't know, so he really can't talk to that, because that's not part of his experience, other than knowing that you did that. Okay.
He didn't, may I answer? He didn't know the name of the app that I
And
downloaded.
he didn't know what it's for. He didn't know its scientific value and purpose. He didn't know how it's otherwise used, whether it's appropriate to use it in the setting that you used it in. It's not a scientific study, and he has no basis and background in doing that kind of measurement, which he said himself. He's never done that before. So he can talk about what he's seen and observed and heard at Apple Hill with regard to the setting of properties from an aesthetic perspective, with regard to noise, and with regard to wind when there have been clear-cutting things that have occurred at Apple Hill, because those fit within his acknowledged experience.
One more question about wind. I provided Mr. Carroll with a NOAA study on wind, which came from the National Center, where the wind experts there helped me through their website to establish the 3 areas of thunderstorm wind, high wind in the Bennington area over the last 20 years. And I have those records, which I handed over to Mr. Carroll, who studied them. So will he be able to use?
No. They are not within his experience as he stated. His
Okay.
experience is practical and personal to that site. He has shown no background by which he can appreciate or understand that makes him an expert. He can have a lay understanding of those things, and he might have understood what they said. I'm not saying he's dumb or anything, but he's not, an expert would appreciate those in a different way, having done other studies themselves. So inasmuch as his testimony is expert,
Okay,
which he can only talk about expert stuff. He's not here as a lay witness because by your intervention, you had to use expert witnesses. He can't talk about that. If you want to submit that as a piece of evidence separately, it will be considered as such, but he can't talk to it. Do you understand?
yes, I thought my interpretation of expert was experiential as well as
And
a degree.
That's absolutely right. And what we've seen is that Mr. Carroll does not have, as you said, he does not have a degree in any of those things.
Okay,
It's his experience that's essential to you as an expert. His ability to interpret a scientific document, isn't part of his experience and background.
okay, thank you. I understand better.
So the other parties understand the rule.
Yes.
Very well. With that, I think, does anybody need a break? We've been in here for, why don't we take 10 minutes and come back at 35 minutes, 25 minutes before the hour. I just want to make sure that, I'm thinking we'll probably be done around 6. Is there any reason why the parties might or might not be able to do that? No comments? Okay, I guess that means you're good.
I would prefer to continue this.
That's what I thought.
It's so hot and my cats will be dead when I get home. So, I have a 3-hour drive home.
You have a basement?
Yes, I do.
All right, well, let's go ahead and get started then. We'll start off with,
No need to take them out of order now, from my perspective.
unless Mr. Kane really wants to go first. Are there any witness issues with time? No? Okay, now we'll go ahead and take whatever order you want to present them in, Mr. Malone.
I think we'll start.
Actually, I wanted Dory Barton's testimony
Yeah.
first.
I'd
Start
like
Dory
2
and then-
women at a time. Mr. Towsley?
Yes.
By my saying, I'd like a continuance, I meant that I would prefer to continue this at another time so that we could end at an hour when. So are you going to go to 6? Or?
That's where we're going right now, yes. Unless you can't do that. You'd have to be here tomorrow morning at 9 o'clock. Everybody would have to be here tomorrow morning at 9 o'clock.
Okay. May I make a phone call?
Sure.
Thank you.
The system was such that they couldn't do something simple like that. Jesus, I could do it with WordPress and create a record for every single case.
Let's go ahead and get started. And up first will be Mr. Malone wanted to enter into evidence the pre-file testimony of Dory Barton. You may proceed.
I'd like to move for the admission of the pre-file testimony of Dory Barton dated as of February 23rd, 2015, consisting of 5 pages, and the pre-filed supplemental testimony of Dory Barton dated as of June 29th, 2015, consisting of 6 pages, and including all the attached exhibits thereto, which are exhibits AHS MK1 through 7, which are exhibits AHS DB1 through DB3. And in support of that testimony, I have submitted an affidavit of Dory Barton dated as of July 30th, 2015, attesting to the truth and accuracy of the aforementioned testimony.
Is there any objection?
No.
No.
Very well. The testimony, pre-filed testimony and exhibits of Dory Barton are admitted as evidence.
I'd like to call Mr. Kane.
Very well. You may proceed.
Just one.
You swear to affirm under penalty of perjury that testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Can you state your full name for the record
Mark D. Kane.
and your occupation?
I am Director of Community Planning and Design for the firm of SE Group based in Burlington, Vermont.
And do you have in front of you two sets of pre-filed testimony? The first dated March 3rd, 2015, consisting of 7 pages.
I believe in the actual packet from Kim, there is no pre-filed testimony, so I'm assuming that's somewhere else, but I do have a copy.
Okay.
Yes.
And the second supplemental testimony dated June 12th, 2015, consisting of 5 pages. Sorry, that would be June 29th.
Yes. Yes, I do.
As well as exhibits AHS MK 1 through 7.
This is missing 7.
And your list only has up to 6.
Yep, sorry, 1 through 6.
Yeah.
And then with respect to your supplemental testimony, exhibits AHS SUP MK1 and MK2.
Those are all marked as part of exhibit MAHS Sup 1 MK1.
Correct.
Yeah.
Were all the aforementioned pre-filed testimony, supplemental testimony exhibits prepared by you or under your direct supervision?
They were.
Are there any corrections to that testimony or to the exhibits at this time?
No, they're not.
And are they true and accurate to the best of your knowledge and belief?
Yes, they are.
I'd like to move for the admission of the pre-filed testimony of Mark Kane, including all the exhibits there too, which are exhibits AHS MK1 through 6 and exhibits AHS SUP2 MK1 and MK2.
Is there any objection?
None from the department.
Very well. Pre-filed testimony, supplemental pre-filed testimony, and exhibits of Mr. Kane are entered into evidence.
I have some additional questions for Mr. Kane.
Okay.
Mr. Kane, a question that has come up repeatedly in this docket as of late is whether or not your aesthetic analysis contemplated in this docket included the cumulative effects of both the Apple Hill project and the Chelsea Solar project. For the record, can you please state whether your aesthetic analysis in this docket includes the cumulative impacts aesthetically of both projects?
It does.
Mr. Kane, the Bennington Select Board met this past Thursday, as we've discussed earlier today, to determine whether or not to intervene in this docket. A video of those proceedings was made available on YouTube. Have you seen this video?
I have.
And in this video, what did you see related to your exhibits?
From the review of the video, it appeared that one of the figures, I think it was figure 6A from my supplemental pre-filed testimony, was presented in front of the Bennington Select Board as a characterization of the potential visibility of the project from the Bennington Welcome Center perspective.
And was that the only exhibit that was prepared with respect to that viewpoint?
Absolutely not. There, in addition to that new viewpoint, which was provided in response to questions raised by the Department of Public Service about whether or not our analysis had, our model, our computer model, that was part of our analysis, had considered both the Chelsea project and the Abbott Hill project. That exhibit was presented that showed a red dashed line indicating the location of the Chelsea project in relationship to the Apple Hill project. And that illustration also did not show any of the existing ambient vegetation that exists south of the property, within the state right-of-way and along the southern boundary of the property. It was only provided for clarification of the fact that the modeling and the analysis that was used included both projects. Also submitted with that supplemental testimony was an additional figure, figure 6, that actually illustrated the same view using the same model and including the presence of the ambient vegetation that exists along that southern boundary intervening between the Welcome Center and the project site. And if you examine closely the difference between those two figures, what you will see is that the visibility of the project is significantly diminished by virtue of the presence of that existing vegetation that will remain. I would also just add for clarification, and this was included in my supplemental pre-file testimony, that all of the simulations that were prepared by me and under my direction did not include any of the landscape mitigation elements that were proposed ultimately. So those characterizations of the potential visibility were, in my mind, in my opinion, worst case scenarios in the absence of any mitigation.
And can you think of any reason why the Bennington Select Board would have only been provided with those worst case scenario
I'm not
simulations?
gonna lie, that calls for speculation, so.
Did the petitioner modify the screening plan at all after discussions with the department's aesthetics expert following the project's public site visit?
Yes. As a result of the public site visit, there were a number of questions raised by the department's expert witness related to the mitigation proposed. Originally, the mitigation that was proposed in my January filing was called for the addition of supplemental landscaping along the northern and southern portions of the property to be installed post-construction once the clearing of the property had been completed. And the rationale behind that was that once the clearing of the property was complete, we'd have a better idea of potential visibility into the site from off-site vantage points. In conversation and interaction with the department, there was a desire to add some additional areas of mitigation, in addition to modifying the fence line to provide a little bit more natural vegetation, particularly in the southwest corner of the property, where the property line sort of juts away from the state right-of-way. And as a result of that interaction, we modified our landscape plan and site plans, for that matter, to accommodate that proposed change. We also, in the supplemental filing that was completed in June, provided additional details about the nature and composition of the landscape mitigation and clarified its, the species composition, the install heights, and provided a lot more definition as to what was being proposed.
And how do those changes discussed with the department, or that resulted as from the discussions with the department, contribute to the overall effectiveness, in your opinion, of the petitioner's screening plan?
The original approach, as I had made asserted in my original testimony, I felt that the off-site visibility of the project was already fairly minimal, except for some small areas, by virtue of the retained vegetation that's going to exist within the state right-of-way. There is no clearing proposed for the project outside the limits of the project south of it, and there are hundreds of feet of land area in that area that would be maintained as vegetation. That being said, in conference and in consideration of the department's position, we did do additional landscape mitigation that we think will further benefit the off-site, the minimization of off-site impacts from the project, and add to the effectiveness of the overall siting of the project in terms of its potential impacts on those who are looking at it from off-site.
No further questions.
Ms. Harris, do you have cross-examination?
I do. Please point to the exhibit in the record showing the most recent simulations for the Apple Hill and Chelsea solar projects, showing both built out aside from figure 6 of your second pre-filed testimony.
I would direct you to Exhibit AHSMK2 and point to you figures 6 through 10, which constitute simulations from various vantage points in the vicinity of the Apple Hill project, including locations along the Route 7 corridor and the Route 279 corridor. Those simulations.
I'm sorry, I don't have that. Could you provide?
This is the original report that we prepared.
I have no knowledge of that report.
Okay, well, now, we had the opportunity beforehand to talk about, you had his list of exhibits, and I asked you all, do you all have copies? And you didn't say you did.
The exhibits are listed AHSMK3 and so on, but the file names are different. So I don't know how to find the things.
Do you have exhibit, which one is this?
AHSMK2,
AHSMK2.
dated February of 2015.
Nope.
Did you have Mr. Malone's list of the exhibits he intended to bring into evidence?
I was given to them when the
And
hearing
when I
started.
asked you, do you have all the documents that are on here, did you hear me?
I'm frankly overwhelmed.
Okay. What is it that you're thinking about now? What are you trying to do?
It's not in the binder.
Would you like to be provided with a copy of that document now?
Yes, sir. May I have a second to look at this?
Sure.
On the record, can I understand which testimony or
AHSMK2.
Jamie, it looks like
which is our
this.
report. My
the
report-
original report?
The original report in February of 2015.
Oh, AHSMK, I'm sorry. I kept looking at these people, AHS sub 1, sub 2, sub 2 MK2s.
Saying
My
this
brain.
is
Same
MK2.
here.
He's saying
Right, I get that, but I'm saying the supplemental is in the document. It's with the testimony. Oh, yeah, I've looked at this in
they call this the simulation.
So now, and repeat your question, ask them again for the answer, where is that?
So,
No, it looks familiar. Man, I've been definitely here.
You may proceed.
thank you. So, what I'm asking is for you to point in the exhibit, in this record, showing the most recent simulations for the Apple Hill and Chelsea solar projects, showing both built out, aside from figure 6 of your second pre-filed testimony.
Okay. So, again, referring to AHSMK2, which is my original report filed in February of 2015 that accompanied my pre-filed testimony.
Okay,
In that report, there are a series of figures beginning figures 6 through 10, which represent 3D model views of the project, and I'll clarify that in a moment, from various vantage points in and around the property. That 3D model that was used to generate those simulations, it consisted of both the Chelsea Hill project and the Apple Hill project. This was the basis of a question by the department subsequent to the filing, clarifying whether or not we had done so. And in that, my response to that question from the Department of Public Service, we prepared the figure 6 supplemental that you're referring to originally, that had indicated again in a red dashed line the location of the Chelsea project relative to the Apple Hill project. So throughout my testimony, I considered both projects in terms of the potential for off-site visibility and prepared simulations to document the conditions of off-site visibility, again, in the absence of any mitigation that was subsequently proposed.
Okay, thank you. Can you please point to the simulation in the record that shows what the project would look like traveling north on Route 7 from the on-ramp so that the project would be on the right?
I would again refer you to AHS MK2, figure 9, which is a view from the Route 7 northbound on-ramp. As you'll note on the figure, there's a little dot that indicates VP on the upper right-hand corner context map. That is the location from which that simulation was taken.
Okay. Can you please point to the simulation that shows what the project would look like traveling south on Route 7 after the Shaftesbury exit as one is approaching Bennington?
Because of, in this particular docket, because of the location of the Apple Hill project on the southern part of the overall property, I did not prepare a simulation from that particular vantage point. However, in the Chelsea Hill docket, there was a series of photographs taken from that location that you're referencing, approximately that. Chelsea Hill, as you may recall, the Chelsea Hill project, the Chelsea project is north of the Apple Hill project and more proximate to the Route 7 northbound corridor. Apple Hill, being southern south of that, was not. I did not do a simulation from that vantage point because, I should probably refer to Figure 1 in my original report. If you look at that figure, what you will see, Figure 2 would be better. Along the northbound edge of the property, Figure 1 and Figure 2, along the north and western edge of the overall property, and this is going beyond just the Apple Hill section, there is substantial vegetation along the Route 7 corridor. So it would not be possible, in my opinion, to see the Apple Hill project as you approached Bennington from the north until, it wouldn't be possible as long as you're looking southward.
So you have not done a simulation of the cumulative impact of both projects from that Route 7 South location?
There was no need to do a cumulative impact of the Route 7 South location, having concluded in the Chelsea project that there was no visibility of it from the north. So if the Chelsea project wasn't visible, my opinion was that it wasn't possible to see the Apple Hill project.
Okay, thank you. How many visual vantage points are there during that circular entrance to the Welcome Center for visitors coming in from the south?
As my report mentioned, there are a number of locations along the Route 7 northbound 279 corridor, which I have documented in my report, from which the vantage point, the project may be visible. You can't necessarily quantify the exact number of vantage points because, as has been testified in my report and testimony, this is a car-oriented view shed primarily. So an observer within this view shed would more likely be, other than the rest area, which has been evaluated separately, would more likely be moving through that vantage point. And the duration of visibility from within the view shed is relatively small, given the mobility of observers within it. So there is no specific number of viewpoints. It has been denoted, and one of the reasons that I have concluded that this project created an adverse impact under the Queechy test is because it did have potential visibility outside of its limits within that transportation environment associated with the Route 7 and 279 corridor.
Okay, please see the file named Markane Exhibit Part 1, Part 2, Part 3. See page 4, Figure 4. View F, looking north from Orchard Road towards the project site. Do you see that?
I don't have the PDF file names on here, so I'm going to have to. Do you know if that was my original report, or was that even Apple Hill?
It's a standalone PDF. that has 8 figures with 3D perspectives.
I don't have that in front of me.
February 2015.
Okay, well, the February 2015 filing that's been submitted into evidence from my report contains 10 location of this project, relationship to Chelsea Hill, and the power line extension that was originally discussed during the Chelsea project, as well as the effect of existing vegetation on ameliorating the views.
Are you aware that both are labeled figure 6, as if there's no distinction?
Yeah, I believe there's a different title on them, so there may be a typographical error of 666A, but the information on each of those two representations is different.
I hope that the Public Service Board can appreciate how lame I sound, because it is so difficult for a private citizen to wrap her mind around these massive filings and the different, as you professionals can understand it, it's so difficult for me to wrap my mind around it. And I'm sorry to be taking up time, but I just,
I understand that. Do you have additional
Thank
questions
you.
for Mr. Kane?
Thank you. Okay. Will the screening provide any buffer from wind or traffic noise?
The intention of the screening that we provided, and just to clarify, the supplemental filing included a landscape plan with a key landscape list of species, identifying quantities and sizes, initial sizes. The intention of that mitigation was directed towards offset visual impacts, not necessarily to have an effect on noise or wind.
Mr. Kane, are you qualified to answer that question?
I don't know the ambient wind levels enough to know whether or not there is A, an issue, and B, whether or not this would ameliorate that issue.
Understood.
Can you please describe all the screening that will take place for both projects combined? What is the screening plan for the western side of the project? Please point to the page in the record that describes this screening plan.
Okay, so I don't have the Chelsea filing in front of me, so I'm not going to be able to talk to it in general terms. I'll talk in general terms. Start with Apple Hill. There were 2 areas that we had identified. This is AHS Sup 1 MK2. It's probably the best place to look at that. There was a figure called figure 2 and figure 2A, which is the basically it's labeled as site plan, but it includes the landscape mitigation proposed. And in that figure, you will note along the western edge, extending southward and then wrapping around the southern boundary of the property and extending eastward across the entire 2/3 of the frontage of the project to the state right-of-way is a proposed mitigation planting area. In addition, along the northern property boundary, extending the entire length of the northern property boundary, is an additional landscape mitigation planting area. Thirdly, there is, and you have to go to the second figure because we kind of ran out of room on this one, there is some additional supplemental plantings placed within the state right-of-way, and we have worked with the state of Vermont to verify that they would be acceptable to that, and they have agreed that that's acceptable. Mature of pine trees, essentially, to further enhance the potential screening of the project from off-site. So all in, between the northern property and the southern property boundary and the supplemental pines that are located along the in the state right-of-way, outside of the project, off-site mitigation, if you will, we're approaching over almost 600 shrubs and trees that are being proposed as part of the mitigation, which, from my experience on solar projects, is almost a factor of 2 beyond what has normally been done.
In your filings, you talk about after completion, further mitigation that will be decided. So how will that be decided then?
Well, and it's a very good question, because one of the things that we have included in my testimony, I include my testimony, is this mitigation plan is shown basically as a reference and identifying these areas as areas of potential mitigation. I would still assert that a post-clearing review of the property be done so that we, as part of the landscape architectural consulting team and aesthetic consulting team, can look at the property from those off-site vantage points that we clearly identified in my testimony to ascertain whether or not some of that mitigated landscaping could be shifted around to more optimize its potential to screen the property. And I still think and hope that that actually would be a very reasonable thing to do. With nearly 600 individual trees and shrubs, there is ample scale into the palette of material to work with, from my perspective, to place strategically. And as the simulation showed in the original January filing, there were very few areas from offsite where there was sort of potentially open views. And I would hope that we would prioritize the installation of the landscaping to maximize the screening in those, from those vantage points.
Well, since my property is on the northern boundary of where you're going to be doing proposed mitigation later on, and we had discussed before of the after, and how do I become part of that process to ensure that there will be mitigations that will help screen the 14-foot road that's going to go over the north end boundary?
As I understand it, you actually abut the Chelsea project, is that correct?
Yes.
Okay. So this is sort of switching dockets a little bit here, but the strategy, the landscape mitigation strategy we proposed in Chelsea is consistent in character to what we're proposing here. And I think by virtue of you being actually part of the process, you're already embedded in this, but you know, the presumption would be that the board would file a condition that would say post-construction, review the clearing, the aesthetic consultant would then finalize a mitigation plan based upon the input of the department, perhaps the neighbors, and the petitioner to come up with something that is reasonable and achieves the stated goal of ameliorating and minimizing the impact. The quantities and species composition and orientation of the plantings that are depicted in the figures are meant there to help us understand if there is a reasonable solution, and I believe there is, and also to provide some sideboards for what that might look like, so that the petitioner is not saddled with $100,000 of additional mitigation by virtue of going through this process. I think, both in Apple Hill and itself, Opinus to Chelsea as well, that what is being provided in terms of the quantities and composition of species and locations of where we've identified their potentially effectiveness will, upon completion of this project if it's approved, result in a better condition relative to the off-site impacts than otherwise would be seen.
So it would be the Public Service Board itself that would determine the completion of that at the end?
Well, I can't speak on behalf of the board, but I have concluded in my testimony that this additional mitigation is appropriate. It's mitigation. It's now part of the record as being part of what the petitioner is required to do. If upon the construction of the project and the clearing of the project and the establishment of where the priorities for landscaping are needed, is determined that some things can be shifted around and other things can be shifted around, and the net effect of that is still maintaining the integrity of the.
Maybe we can wait. Mr. Wilson, did you participate in the shaping of the DPS MOU?
Yes, I did.
Okay, because the terms of the post-construction site visit and mitigation are addressed in the DPS MOU, and he might be able to better address that than Mr.
Okay,
Kane.
good, thank you. Do you know what is the budget for the screening?
We haven't done a formal cost estimate, but based upon my experience, this is approaching $70,000 at least, just for Apple Hill, by the way. If you add the Chelsea, you're well over 100.
what is the screening plan for the eastern side of the project?
There is no, there is as the site plan, again, AHS sub MK2 shows, right now there is no proposed mitigation along the eastern edge. The area, the lands to the west, to the east of that are presently wooded and very densely forested, so there's no potential for offsite impacts.
What is the screening plan for the northern portion of the project? Please point to the page in the record that describes the screening plan.
Okay, so I would again bring your attention to AHS sub MK2, figure 2, which shows a landscape, a proposed mitigation plan along that northern edge, extending the entire length of it. In addition, that landscaping is described, there's a plant list, a key associated with that on that same figure, and that is described in my supplemental pre-file testimony.
So, does it involve leaving any of the trees? You talk about on the borderline, but it's not clear to me which part of the trees on that northern section of Apple Hill will possibly be left to help buffer.
Okay, so that's a good question for clarification. So as my testimony mentions, there is clearing in the property. There's a large amount of clearing in the property. But along that boundary line, where trees are off-site, off-property, clearly those cannot be cleared. Those are off the property and they're not under the control of the petitioner. So if there's a large tree that happens to be a foot north of the property line, that tree is staying. In addition, the petitioner has indicated that they would be looking at those trees that are straddling the line and try to find ways, if there's possible, to sort of keep the ones that can stay. Because a tree is not a tree is not a tree. There are some that are not going to get to a height that would pose a fall hazard risk to the solar project, which is one of the concerns that has been raised. And in addition to that, there are areas along that edge that are lots of scrub and secondary growth and successional species. And to the degree some of those can stay, I think that would be an evaluation of on-the-ground construction. In addition, we're also, as I mentioned, we're proposing a significant amount of mitigation there. So our hope would be that as a real detailed understanding of the composition of that frontage or that boundary is understood from a plant perspective, there may be areas where nature's taken over and it's going to do fine for mitigation and we wouldn't need to add anything. I would presume there would be some other areas where trees along the boundary on the petitioner's side of the boundary would have to come down, and in those areas where we prioritize new landscape mitigation to minimize the offset impact.
Does it concern you that clearing the trees to the south might result in weakening the existing trees and cause them to fall over in high winds?
That is a concern, and I think one of the things we would want to look at in the clearing process is where those trees are relative to the boundary. If there's some that can stay, then maybe they can stay. It also depends on the species that we're dealing with. Some trees will withstand wind better than others, and we don't have a detailed, nor would it be appropriate to do a detailed inventory now because it's a very complex effort, a detailed inventory of every single tree along the boundary. But if the clearing were to commence, looking at those species along the boundary, trying to find ways to minimize clearing if possible, and prioritizing areas. For example, if the tree is a fall hazard and it's on the petitioner's property, and that may come out, that would probably likely come out because it wouldn't be something that would be able to coexist with the solar project. Again, in that area, we want to prioritize the installation of new material that is going to be more capable of addressing the conditions on the ground.
Are there
I want to
any?
make sure I understand your answer. I think what you said was that the project cares about trees falling down because they might fall on the project.
That's true.
Okay.
Are there any elevation drawings showing the plantings?
We have not prepared any detailed simulations of those plantings at this point, no.
So what concerns me as an abutter to both is that, what level of comfort can I have that there will be left the tall trees that are still there on that northern end to help buffer noise and wind?
Well, as I said, I think within the limits of the project area, there is nothing that I can say that would guarantee that any of those trees could remain, because again, that's gonna depend on the conditions on the ground. The petitioner has proposed to clear the limits within the property. However, along the shared property line where those trees straddle the boundary line, there is going to be some, I was thinking, consideration of those trees and where they can remain, they could remain. On your property, that is obviously not going to be affected. And, this is getting outside of the realm of Apple Hill at this point, but it applies to this project relationship to all its boundaries in general. There are substantial vegetated areas outside the limits of this property. The homes north of Chelsea, the location of properties adjacent to Apple Hill are not 10 feet from the property line. They're a substantial distance, 365, 700 feet away. And in those intervening distances, there are trees that are outside of the petitioner's property, the property the petitioner will control, and cannot be cleared and will not be cleared. So to the degree you're looking from your home or any neighboring home on this property out through trees, I would presume that a good majority of those ones in the foreground are yours. And this project would have no effect on those at all.
Is there a cap on the amount of money to be spent on screening?
That's not something I've evaluated, so you have to ask somebody else that question.
Do you think it's reasonable for the public to want to understand the aesthetic impacts of these projects and their cumulative impact?
Yes, and I believe that I believe that my report and the work that I have done to ascertain and characterize and present and propose mitigation for this project is a significant effort to document the potential impact of this project on the neighbors and the surrounding public. And as I mentioned at the beginning of my testimony today, I concluded that the project does result in adverse impact, and that means something to me. And it's important to recognize that this isn't a matter of just sort of not doing analysis to come to a conclusion. In so concluding that this project is adverse, I had substantive conversations with my client about what we could do to address those issues. And that has subsequently got them on the hook for a very robust and expensive mitigation plan.
One last question. If the Bennington community determines that the screening is inadequate, what further mitigation could be done to reduce the visual impact of the project?
Well, I think this goes into a real fundamental question as to whether or not the purpose of mitigated screening is to completely obliterate the potential visibility of a project. And I can think of no other land use in the state of Vermont that I'm aware of, and as Vermont Director for the Northern New England Chapter of the American Planning Association and on the Vermont Planners Association Executive Board, I get a chance to see a lot of projects. I can think of no other land use in the state of Vermont which actually requires a project to be completely invisible to its neighbors or surroundings. This project has done an incredible job of trying to understand its relationship to both important off-site public vantage points as well as close neighbors, and has proposed as I mentioned several times, a very robust and expensive mitigation plan to rectify and deal with those impacts. It is not without impact. I have not stated it's without impact, nor will it be without impact. But that is not the bar under which the Queechee process in my opinion, evaluates the outcome of the project.
So am I belaboring the point to ask you, could further mitigation be done?
I don't believe there is anything that could be done that would completely render this project invisible from everybody, if that's what you're looking for.
Okay, thank you, that's it. Again, I'm sorry for my ingenuous.
It's okay, it's okay. You're asking questions, I understand. Are there any further questions for Mr. Kane?
I have a few, if I may.
Sure.
Concerning figure 2, and I'm sorry this is separated from
AHS sub
Parents.
MK2.
I
think.
believe so, the plant species for landscape mitigation.
Yes.
So I've got a 2A and a 2 on opposite sides of this page. And if you wouldn't mind, just walking me through this a little bit, or you can point me in the record towards testimony or some other source that further explains what I'm looking at here. So I see the project fence and there's the proposed mitigation planting. What is the purpose of the cleared area past the project fence?
So, and I think Mr. Wilson may be able to provide more light on this limits of clearing, but the limits of clearing in general are to prevent shading of the actual project from trees to the south of it. As you can imagine, orientation towards the south is an important consideration in siting a solar project. So on this particular site, there is a necessity to clear some of the southern area to allow for minimization of shade.
Okay. And the very light dotted lines that are inside that area, in between the limits of clearing and the project fence, are those for some sort of path or roadway?
No, those dashed lines are actually contour lines associated
Okay.
with the grades of the property.
And with these simulations, do any of them depict glare off the solar array, particularly from the roadways?
Again, the purpose of these simulations was to show the location of the project relative to offsite visibility. But I would call your attention to my pre-filed testimony and report. And in that report is an attachment which includes the modeling analysis that we completed for solar glare hazard.
So this is part of the aesthetic analysis report AHS-M2-MK-2?
That is correct. And in that model, in that report, we used a computer model that helps to evaluate the potential off-site glare of a project related to its surroundings. And we applied that model to this site in the absence of any vegetation, which I think is an important note. We did not include any vegetation in terms of the off-site impacts of the potential for glare. The results of that analysis were essentially that there was very little issue related to glare hazard.
In looking at your plant species key here, you're designating just white pine for trees? That's the only species?
No, well, technically yes, but one of the things that the plant list includes is actually white cedar is included on there, and depending on the form it can take, that gets to tree height fairly rather readily, and would have a year-round screening effect. Just to clarify that too, I think one other thing to recognize and remember is the maximum height of the panels on this project are 12 feet high. So the mitigation that's been proposed includes a variety of native shrubs and trees, and a lot of those shrubs left to go into naturalized form, which would be the intention here, can easily get to 12 to 15 feet high.
And that's at full
Full maturity.
Well, the panels, if will they move?
No, they do not move. They're fixed, oriented to solar south, and maximum 12 feet high.
So if I understand correctly, there's this limits of clearing line, and so you have some designated pointers to existing vegetation to remain, which I understand that is the state-owned land. It's below the tax parcel boundary. So the area to the west of that limits of clearing line that's inside the tax parcel boundary, that will also be vegetation to remain and not cleared.
So yes, so just to clarify, so we're talking about the southern boundary of the property, that's in yellow.
Yes.
There's a wedge of land that is along the southwest corner of the property that will not be cleared following the construction of either the Chelsea or Apple Hill projects. both that area of retained vegetation in that southwest corner, both straddling both the state land and this property will not be cleared.
And I noticed in the discovery responses that there was an answer about Vermont Trans getting back to you all about planting on the state land. And I see on figure 2A, there's a pointer, proposed supplemental mitigation planting on state land to screen view from visitor center. So is this a result of a response that you did receive from V-Trans?
No, this came about, again, as a result of some interactions with the department. They felt, based upon some final sort of review of the property project, that sort of more foreground landscape mitigation, i.e. within the state right-of-way, may be effective. I respectfully did not concur with the necessity of it, but in consultation with the petitioner, agreed that it certainly wouldn't hurt to add it. As is noted on that plan and is mentioned in my supplemental testimony, you know, it is offsite mitigation. It is outside of the control of the petitioner directly, and if for some reason the V-Trans felt they needed to cut one of those trees down, there would be very little recourse that the petitioner could do because it's not a property. But in combination with what we've intrinsically proposed, I think it's certainly going to be more effective.
So what is the current status of the correspondence between you and V-Trans about planting offsite?
Yeah, I think that would be a question that would best be directed to Brad, because he's been involved with those day-to-day consultations, or week-to-week.
Okay, those are all my questions, thank you.
Any of the parties have any questions? No. Is there any redirect? Well, Mr. King, you may stand up. Oh, did you have
I have a couple questions.
Oh, sorry.
Looking at your, I'm looking at figure 9
Yes.
in your pre-file. Does that depict the Green Mountain Power line that will be built along Willow Road?
Oh, no, it does not. This vantage point was done before that finalized the location of that line. And so this figure does not present that loose interconnection line.
Do you have any information on what trees Green Mountain Power will cut along?
It is my understanding that as it's depicted in my supplemental testimony, that for Chelsea, it's kind of confusing, but in the supplemental filing I did for Chelsea, there was a discussion about the proposed route, and much of the route actually takes advantage of an existing Willow Road right-of-way. So I think within that limits of the right-of-way, there's not a lot of clearing that needs to be done to accommodate the interconnection. Most of it is actually open at this point, because it's actually, you can drive right up to the site, to the Apple Hill site.
In your opinion, will the GMP line be visible?
Not from that vantage point, I don't believe so. Obviously, there is some potential visibility from the sort of point south along the Route 7 northbound ramp, perhaps, where it's more proximate to potential areas. But that 279 shot that you're referencing figure 9 from is far enough away, and I think that the poles would be set against the significantly mature vegetation that exists to the east. So if visible, I don't believe they would have much of a potential for impact.
Okay. Are you familiar with the MOU with the Department of Public Service?
No, I'm not.
Well, do you have a copy of it?
Save that for Mr. Wilson.
Do you have a copy?
I do not.
No.
Can I have a copy?
Yes.
I do.
And I'm looking at 5E.
Okay.
based on the, your knowledge of the views, does that have any value as far as for aesthetic improvement?
Based upon my review of the project and the consideration of the vegetation that's to remain, I don't believe it'd be cost effective or valuable from an aesthetic perspective, I should say, to bury the line. The form that this interconnection pole would take, regardless of whether it's visible, is something very consistent with what everybody sees everywhere else in terms of the surrounding area. These are 38 to 42 foot tall wooden cross-armed poles that are going to basically be set against large vegetation that exists to the east. And whether or not the tips and tops of them are actually visible, I don't think would create an undue adverse impact.
I wanted to look at number 6 with you.
We're still in the MOU.
Yes, I'm sorry, yes, still in the MOU. And on number 6, it has it calls for a post-construction site visit. And I'm assuming, based on you talking about Chelsea and Apple Hill, you probably think that your opinion might be that they should do them together?
Well, I think if the construction sequencing allows, ideally that would make a lot of sense.
Now, that has a cap on, if during that site visit, that we include additional mitigation if warranted, but it has a cap of $5,000 on it. Do you think that's reasonable for the board to?
I think in this case, given that this is an above and beyond which has been actually included in our mitigation plan, and as I mentioned, this is if you take those costs associated with the mitigation plan and you run it through a cost analysis, what you find is something on the order of $20,000, $25,000 in trees and $30,000 in shrubs. The additional $5,000 may be adequate. I am, based upon my site visits to the area and my review of the project and property, I think what we'll find at the end of the day is that a large part of those two boundaries, which are being proposed for mitigation, don't really need it, and that those landscape mitigation assets that would be, which are basically being required as part of our mitigation plan, could be deployed elsewhere to further bolster their effectiveness. So I think that the $5,000 additional amount is put in there to provide a fail-safe in case there is a particular area that may benefit from some additional mitigation. And I think it is reasonable.
Questions, why are those questions and answers? Yes.
Yeah, I'm not sure if you're familiar with all the details, but I want to go back to the first question that Mr. Watts asked you about paragraph 5E in the MOU.
Yep.
And specifically call your attention to, I'm not sure you're reading this correctly, and I want to clarify this for the record, but just take a look at that paragraph and tell me if you see anything in there that requires undergrounding, because I think that was in your answer to
Yes.
Mr. Watts. Just take a moment, because I know you didn't.
Excuse me, yes, you're right, to clarify that, it's ground mounted.
Right, so
Right.
let me ask you this, if this paragraph in the MOU refers to ground mounted equipment as opposed to pole mounted equipment, which I have outside information that was intended to do so, do you have an opinion on whether ground mounting equipment might minimize visibility of project equipment, that pole mounting that same equipment would not?
Yeah, I think in this particular case, given the distances between potential observers in the project, I mean, all of the vantage points that I've been talking about in the report are 5 to 1,200 to more feet away. Even the welcoming center is 1,200 feet away approximately, 1,000 to 1,200 feet away. I don't think the visual difference between a pole mounted and a ground mounted supportive structures would make a difference in terms of the aesthetic outcome, particularly given the fact that there is a significant amount of intervening existing vegetation that is not going to be disturbed between those potential observers and the components that are in question.
Okay, thank you.
Other questions from the parties?
No?
Any lead right? Now, Mr. King, thank you.
Thank you.
Mr. Wilson?
So you're trying to find, okay, yeah, it's confusing.
Do you have your pay file?
I do not.
I'll get it out. You have enough at the end, right?
It was there.
Evening, Mr. Wilson. Do you swear or affirm under penalty of perjury that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may proceed.
Can you please state your full name for the record, Mr. Wilson,
Bradley John Wilson.
and your occupation?
I'm a project developer for Apple Hill Solar LLC.
And do you have in front of you your pre-filed testimony dated March 3rd, 2015, consisting of 22 pages, as well as petitioner's exhibits AHS Ecos 1 through 10?
Yes, I do.
And were those prepared by you or under your direct supervision?
Yes, they were.
Are there any corrections to that testimony or to the attached exhibits at this time?
No.
Are they true and accurate to the best of your knowledge and belief?
Yes.
Do you have in front of you petitioner's discovery responses to A&Rs and the department's first round of discovery, each dated May 20th, 2015?
No, I don't have the discovery responses. Yes, now I have those documents.
And lastly, do you have in front of you the two memorandums of understanding that were entered into between the petitioner and A&R and the petitioner and the department, each of which were dated June 29th, 2015?
Yes, I do.
And were those MOUs and those discovery responses prepared by you or entered into with your supervision?
Yes, they were.
Are there any corrections or clarifications with respect to those discovery responses or the MOUs at this time?
No.
And are they true and accurate to the best of your knowledge and belief?
Yes, they are.
I'd like to move for the admission of the pre-filed testimony of Brad Wilson, including all of the attached exhibits thereto, which are exhibits AHS Ecos 1 through 10, as well as the admission of the petitioner's discovery responses to A&R and the department, and the two memorandums of understanding, in each case, including all exhibits attached thereto.
Is there any objection?
No.
No.
I would like to ask that these exhibits, all of these exhibits have an additional tag which shows exactly what file. There's something of a description on the right, but the way I access them is through a file name.
So you're not objecting to the exhibit itself?
Right.
You're objecting, so you do not have paper copies with the sticker on it?
Right.
So is there a particular document that you're concerned about knowing which one it is?
No, it's all of them because I can't refer to them.
Do you have the petition of the petitioner? Okay, it's included in there.
But this has a load of supplemental filings and it's
Not
beyond
under
me.
Mr. Wilson's testimony.
Hmm?
The only ones, which ones are supplemental that you're referring to?
Okay, is the supplemental Mark Kane?
No, this is Mr. Wilson's though, not Mr. Kane's.
Okay. Okay, so, okay, I'm okay with this.
Okay. If there's no objection, the pre-filed testimony of Mr. Wilson, the exhibits attached there too, as well as the discovery responses from the department, to the department and to the agency, as well as the memorandum of understanding with the department and the agency are entered into evidence. You may proceed.
Mr. Wilson, Mr. Kane just testified as to the maximum height of the panels being 12 feet, and Mr. Kane is not as intimately familiar with the equipment as you are. Can you please, for the record, state what the maximum height of the panels would be?
Sure. It may seem like a small difference, but the maximum height of the panels is 9 to 10 feet, depending on the ground conditions.
I don't have any further questions.
Ms. Harris, do you have cross-examination questions for Mr. Wilson?
Yes.
You may proceed.
Do you plan to clear, prepare, and construct and decommission Apple Hill Solar using only Willow Road?
Yes.
Do you plan to clear, prepare, and construct and decommission Chelsea Solar using only Willow Road?
That's irrelevant to this proceeding. You don't get to answer the question. Next question.
Do you plan to interconnect Apple Hill Solar with the new GMP power line being extended more than a mile along Willow Road to serve the project?
The Apple Hill project will interconnect to the GMP grid that you described.
Did you make a presentation to the Bennington Select Board about this project?
No?
Did you make a presentation to the Bennington Planning Commission about this project?
No.
What is the current ambient or background noise level in the Apple Hill neighborhood in the vicinity of my home?
I have no idea.
Please point to the noise study in this docket.
There is no noise study in this docket.
Is there a reason you did not submit a noise study in this docket?
Yes. One was never requested by any of the intervening parties.
Did I not ask for the noise level several times of you?
Not as a member, not as an intervening party in this docket. You did have an opportunity to service with discovery in this docket and did not do so.
Am I allowed to ask that now, sir?
What's the question?
The question is, why has no noise study been provided by Apple Hill Solar?
I think he already answered that, didn't he?
All right. Do you understand that traffic noise is a big issue for neighbors?
I really can't speak to what is a big issue for neighbors.
What have you done to address the concern about increasing traffic noise by cutting the extensive forest that is buffering the noise now?
Object to that question. It assumes facts that aren't in the record.
Can I hear the question again?
What have you done to address the concerns about increasing traffic noise by cutting the extensive forest that is buffering the noise now?
It's assuming, the question's assuming that the trees that are there are providing any sort of buffer, and there's nothing on the record that indicates that.
Well, that is the question. You may ask the question. Overruled.
What have you done to address the concerns about increasing traffic noise by cutting the extensive forest that is buffering the noise now?
Let me think about that question for just a moment. I'll start by repeating something from my previous response that we didn't receive anything from any of the intervening parties on this docket regarding traffic noise. We received no questions about it. Mr. Carroll's testimony was the first time we'd ever seen anything formal from you filed into the docket regarding noise. regarding traffic noise, it is an issue that we have considered. It's no secret that we evaluated it in the Chelsea docket. And as it relates to Apple Hill, I really don't know how appropriate it is to translate things directly, but I think our conclusions would be the same if we had been requested in this docket to provide that information. Referencing that noise study that was submitted under the Chelsea docket, it concludes that there would be no undue adverse impact related from the clearing of trees for this project to any of the neighbors in the Apple Hill neighborhood. Therefore, although we have taken steps to address visual mitigation, we haven't taken any specific steps to address noise that is crossing our property but is not being generated by us. And also, no parties have requested that we make any such mitigative measures.
Do you believe that the trees are not buffering the traffic noise for neighbors?
Well, I'll point out that I'm not a noise expert myself. I believe, based upon the results of the study that's referenced in the Chelsea docket, that any noise buffering benefit that may be provided is minimal.
Please see this noise study prepared by the expert you used in the Chelsea Solar Project, Rincon's Chris Birdback for California Flat Solar Project.
I'm going to object to it. That's not part of the record in this proceeding.
What are you trying to do now?
It was provided in the discovery responses,
That was in the other docket.
and this is a cross exhibit to that.
So what do you have exactly?
It is,
You have the noise study that was done in Chelsea Solar.
no, it's a noise study that was done by the same person of the same company that did the simulated noise study for Chelsea Solar.
Okay, so why is it relevant to this proceeding?
Because this has, the same person was hired to do actual monitoring in depth versus simulated modeling.
Okay, so why is that relevant to this proceeding?
It's relevant to this proceeding because I firmly believe that we have asked for noise monitoring and that this actual noise monitoring is and can be easily done, and that what ECOS has provided is only a simulated noise study that doesn't have any bearing on actuality. And we live in a real world, and it's actual noise.
Okay. Has there been a noise study submitted in this docket?
No.
Okay. Has this document been submitted in this docket?
It was submitted in response to discovery when they asked what documents I might use.
Was it provided to the petitioner?
Yes.
Okay, so the petitioner has that document, from your understanding.
Yes. It was at the end of his questions. He asked, what documents are we going to use?
Okay, was that document then provided to the petitioner?
There was a link to the document.
Okay, I'm gonna grant, the objection stands. You may ask the petition, you may ask Mr. Wilson. You've already asked him, why didn't he do a study? You can ask him, why didn't you do a study that did actuals? You can ask him that latter question. But that document has no relevance to this proceeding.
Okay. So have you done any study that's provided actuals?
I'm going to Take what you mean by provided actuals,
Actual
As I-
monitoring.
as I understand it, when performing a study to, you know, describe what the effects of an action could be, you could do as you're saying, which is to take measurements of the existing conditions in the field, or you can estimate what those existing conditions are based upon publicly available information. Now, it's certain that field work is definitely more costly from a dollars and time perspective. When it comes to, and no, we haven't done any monitoring on site. When it comes to simulating what the effect of an action might be, though, that's where you can use the actual numbers or estimated numbers as a starting point, but the modeling of what the effect will be, that's a model, and that's a model whether or not you're starting with estimated baseline numbers or actually measured baseline numbers. In this case, you're asking about what could the increase in noise decibels be if the trees on the project property are removed. And that decibel increase is something that is modeled, no matter whether or not you're starting with an estimated existing condition or a measured existing condition. And I believe, and again, I'm not a noise expert, but I believe that the resulting decibel increase would be approximately the same whether or not you're starting with an estimated existing condition of 60 decibels or a measured existing condition of 70 decibels.
Okay. Has Apple Hill Solar conducted a wind study to ensure that the removal of 15 acres of trees will not cause further hazardous consequences to the Apple Hill community?
Would you be able to define wind study, please?
Forensic meteorologist study.
We have not performed a forensic meteorology study.
Why did you choose not to conduct a wind study specific to Apple Hill to provide evidence that cutting the trees will not result in increased damage to the neighborhood uphill that is benefiting from the forest that is buffering the wind?
Sure. My answer will be similar to the answer regarding the noise study. No parties in this docket formally requested us to perform such a study, and there appear to be no 248 criteria related to the project's ability to buffer the natural phenomenon of wind that just happens to be crossing from over our property onto another property. Such studies have not been included in other solar dockets, so it's definitely didn't exist as one of these things that you just do automatically. We didn't receive any such requests from the department, from A&R, or from you.
If Apple Hill Solar cuts the forest and wind damage occurs, will Apple Hill Solar agree to investigate whether removing the forest contributed to the cause?
I want to preface this by saying it's always our intent to be an excellent neighbor when we have a solar project, and we have a number of them in various locations, and we feel our track record stands very well. But I think what you're asking is that if the clearing occurs and anyone in the Apple Hill neighborhood has a tree fall over as a result of a wind event, that we somehow be liable to put costs into investigating that. Your own expert's testimony currently states that any time that the wind events in Apple Hill are already so fierce that trees come down fairly regularly. And so that's a current condition that's already happening, and it's not something that we would really be comfortable obligating ourselves to tied to a condition of this project at this time.
Well, since you're stating that your every intention is to be neighborly, how, I don't know how to word this. What consideration are you offering the very neighbors you want to be neighborly with?
Right.
I'm gonna cut you short of this line of questioning, ma'am. It doesn't specifically relate to criterion that the board considers, other than the performance of the developer as a good neighbor. And I think he's answered that question.
Okay,
But specifically, the notion of wind damages and the sort of nuisance damages that you're referring to are not within the normal criterion that the board assesses,
all right,
or can take any action.
okay, thank you. At the public meeting, May 20th, 2014 in Sudbury, were you asked by residents why you chose the site?
That's been a long time ago. I imagine it came up. I don't remember the specific questions that were asked of me of that.
If you need your memory refreshed, may I read you the transcript of the public meeting? Sudbury residents, why this site? Brad Wilson. It's open, clear hayfield. If we were proposing to do a project where we had to clear cut 15 acres of native forest, we wouldn't even be in front of you tonight. We wouldn't even have gotten that far. That would just not be allowed. So it has to be clear and open. Were you considering the Apple Hill and Chelsea solar projects at the time you made that statement?
I don't believe so. I was there to speak about Sudbury.
And so, how can you please explain why you said that a solar project site had to be clear and open, yet you are pursuing cutting more than 15 acres of native forest?
I was speaking about the Sudbury site.
Mr. Kane made a lot of promises about how much money Ecos Energy will be spending on mitigation. What assurances do we have that Ecos Energy will follow? Mr. Kane made a lot of promises about how much money Ecos Energy will be spending on mitigation. What assurances do we have that Ecos Energy will follow through with the plans?
Because those plans will be a condition of the Certificate of Public Good if issued by the PSB.
What recourse do we have if your mitigation plans are inadequate?
I would have no ability to advise you on that topic. It sounds like a question for your attorney.
I am the attorney. God help me. Do forests have any value in mitigating climate change? If yes, explain.
Yeah, object to the question. I don't see how it's relevant to the scope of her intervention.
Why do you want to ask this question now?
Well, I'm interested in asking what is the carbon sequestration value of 27 acres of trees? The 27 acres of trees are giving off clean energy in themselves. And
I think you can ask Mr. Wilson whether the cutting of the 15 acres at Apple Hill, whether carbon sequestration by those trees was considered.
okay, thank you very much for helping me. So in the cutting of 15 acres of trees on Apple Hill, was carbon sequestration considered?
Yes, it was.
And how?
There's a 248 criteria that specifically relates to greenhouse gas impacts, and as a developer, we want to make sure we've addressed all 248 criteria before coming before the board. And so that was considered. The very brief answer is that you're correct. Existing trees do provide a benefit not only in the amount of carbon dioxide equivalent that they absorb annually, but also the amount of carbon dioxide equivalent that they store. That's a real benefit. The project also has a carbon dioxide equivalent benefit in that the energy it produces does not generate any carbon dioxide, and the energy it produces offsets a certain amount of electricity that is generated using fossil fuels. And in very brief analysis, the amount of carbon dioxide equivalent offset by the electricity generated by the project far, far, far outstrips the carbon dioxide equivalent benefits of the existing trees.
How many years will it take for the loss of the carbon sequestration benefits of cutting 15 acres of trees to be repaid by the solar project?
You know, this is honestly getting a little bit outside of the scope of my expertise. It's something we took a look at, and based upon, you know, publicly available information from, you know, Vermont State Departments, our estimate is around 3.5 years.
That's it.
Are there other questions that the parties have for Mr. Wilson?
No.
No.
Could I just ask, if you wouldn't mind, on my earlier questions to Mr. Kane, he referred to you possibly knowing in more detailed answers. Would you have anything to add to what he said?
You'll have to refresh my memory on this.
So I was just asking about I guess the V-Trans communications, and if the proposed supplemental mitigation plantings, what the status of that correspondence was, and you know, if that's something that, I'm also interested to hear if that's something that is already factored into the budget that you have for the screening, or?
Sure, absolutely, I can answer that. That's correct, that after the Apple Hill public site visit and public hearing, the department approached us about the idea that could we possibly use lands that don't belong to us, that are owned by Vermont Department of Transportation, to plant some additional screening vegetation. In response to that, we kind of took a dual path. Number one, we put a stipulation in the department's MOU that we would make all good faith efforts to pursue such a plan with V-Trans, and if V-Trans is amenable, implement that plan. With the knowledge that we have no ability whatsoever to compel V-Trans to agree to anything like that. We did approach V-Trans and had some lengthy conversations with them. They ran the issue past their legal department, and they did come back and say, yes, we'd be open to that, with a few little caveats. So I think, to answer another part of your question really quickly before I move on, the figures included in Mark's supplemental and his descriptions of the landscaping plan as a whole, including its budgetary numbers, do account for the landscape mitigation being shown in the Route 7 right-of-way in his supplemental figures. So right now, it is part of the plan to put those in. V-Trans wanted us to be very well aware, and we want to make sure this gets on the record, that although they would be allowing us to make a one-time planting in their right-of-way, they can offer no assurances that they will not have a need at some point in the future to remove those trees for their own purposes. And they wanted to make very certain that there were no conditions upon our project that depended upon the perpetual existence of those trees. Basically, yep, we can work out a deal where you can come on and put some trees in a right-of-way, but we can't guarantee we'll be able to keep them there in perpetuity. We may have a need to remove them for V-Trans maintenance purposes, or maybe construction purposes, or any reason. And so the way it stands is that our plan currently shows a one-time planting of trees in that area, and it's part of what we've proposed, and it's in the stipulation with the department, and it's something we have gotten a green light on from V-Trans.
Okay, I have one follow-up question, and it is along the same lines as my existing vegetation to remain question, which is the area in which you are proposing to include off-site mitigation limited to this small patch on the south boundary, or does it wrap around the tax parcel boundary, the yellow dotted line here? Can it come up not just this limited area to the south, but also around to the west side?
I understand your question. The current proposal only includes what's shown in Mark Kane's figure there. That was the area of concern when the department and their aesthetics witness approached us about this idea.
But that is not true of the existing vegetation to remain. That the areas of existing vegetation to remain does include the western side here where the Apple Hill project meets the Chelsea project line.
Can I ask you exactly which figure you're referring to? I'll pull it up in front of me and take a look.
This is 2A, and I believe it's AHS sub MK2.
Okay. Just a moment. All right, I've got that figure open in front of me. Let's see if you can get me on the page there.
Sure. So, do you want me to just rephrase?
Yeah, if you just maybe rephrase a little bit, now that I've got it right in front of me,
Sure.
I can follow along.
So there's pointers to existing vegetation to remain,
Mm-hmm.
and they are on the south boundary there.
Correct, that's on V-Trans property there, where those pointers are pointing.
So I wanted to confirm with you that existing vegetation to remain is not limited to just where those pointers are pointing, but will also wrap around the southwest and west edge of the project.
Oh, I see. Yes, you're correct in that understanding.
Okay.
Yes, my testimony, my pre-filed testimony and accompanying exhibits clearly defines the limits of clearing for the project, as well as the Chelsea project. And any areas not within those limits will be vegetation to remain.
Could you please point me to the exhibits that you're referring to in your pre-filed testimony?
Sure, the exhibit would be AHS-ECOS-4. That's our site plan document.
Thank you.
It's also very clear on the figure we were looking at of Mr. Kane's. You were looking at figure 2A. If you went back to the previous page, figure 2, this document also very clearly shows the limits of clearing for the Apple Hill site footprint. It's denoted by a black dashed line. Anything outside of that black dashed line is not planned to be cleared for this project.
Okay, thank you.
Yeah.
That's all.
Are there other questions on cross on the parties? We have a couple questions.
Absolutely.
Yeah, I want to go to the MOU with the Department of Public Service.
Certainly.
And again, I want to talk about 5E.
Absolutely.
In the, right at the end, it says that, again, you're talking about taking the pole-mounted equipment and putting them on pad mount positions.
Yes. Could I clarify that just a little bit?
Sure.
This particular item in the department's MOU relates to the 3 poles only that comprise the project's interconnection. These are 3 poles that sit within the project boundary on the project property, and they define the interconnection of the project. I believe the latest design from GMP, 1 pole has a set of utility metering equipment, 1 pole has a set of recloser breaker equipment, and 1 pole has a physical disconnect and also serves as the riser pole, because from there, the cabling goes underground and then on into the center of the solar project. After the public site visit, the department's representative and the department's aesthetic witness were there. They did approach us about the idea of, for those 3 poles, is it possible to do some or all of that equipment pad mounted or on the ground rather than up on poles? And we said we would investigate that with GMP. That's how the stipulation in the MOU came about. There's some similarities here towards the earlier question about VTrans. Since this MOU was filed, we have approached GMP about the idea. They have gotten back to us about the idea. Going to pad mount for this interconnection is a significant increase in the project costs. However, we have elected to instruct GMP to move forward with that plan, to move 2 of those poles down to ground-mounted equipment, because the department had indicated on behalf of, that they were concerned about the visual appearance of those poles, and we want to be as accommodating as possible. So the current plan, and I'm willing to put this on the record, and GMP has this as well, is that instead of 3 interconnection poles at the Apple Hill interconnection, we'll be going to a 1 pole and then the rest pad mounted scenario.
Right. Thank you.
You talked a little bit about the noise study, or the non-noise study that was done in this case.
Yes,
I know that there was a noise study that was conducted in Chelsea Solar.
that's correct.
Noise is an issue that the board cares about, even if the other parties don't care about it.
Certainly.
Based on your assessment of the Chelsea Solar noise study, did you see, was there an impact from noise that it pointed to from the operation of Chelsea?
When you say from the operation of Chelsea, are you speaking to the operation of the equipment that comprises the Chelsea project? Or are you
Yes.
talking, okay. No, there did not seem to be an adverse impact from the operation of the solar equipment. And there is also, in testimony between the department in the Apple Hill docket, related to noise generated by project equipment. And we conclude, and also describe our methodology, that noise generated by the solar project equipment is not an adverse impact, will not be a concern to the neighbors, and will be essentially the same decibel level as ambient environmental noise by the time that noise has traveled far enough to cross our project property boundary.
So that testimony made that conclusion in the absence of a noise study?
That's correct. The reason for that is that the analysis necessary to make that determination is very straightforward. There is a calculation called the inverse square calculation. It's commonly used to evaluate how much a noise source drops in decibels as it travels a certain amount of feet away from its source. We have the specs on the amount of decibels that the equipment at the center of the project creates. That's the only equipment at the project that would create any noise whatsoever. And then we applied the inverse square calculation to those values, along with the distance to property boundaries, and determined that by the time as sound gets to the property boundaries, it's, again, indistinguishable from ambient environmental noise.
Does that testimony that's in the record already related to that conclusion also address the potential, the potential for increased noise due to loss of trees?
No. Well, let me, you might be asking 2 different questions. But the analysis using the inverse square calculation assumes a wide open field. It does not assume that there's any trees helping buffer that noise as it travels. Is that what you're
Okay,
asking?
so what's your conclusion then is because it's an open area that the absence or presence of trees is irrelevant? To the final conclusion that the equipment of the project will remain below the Bennington and international standards?
I think I understand what you're saying. Yes, the inverse square calculation was performed assuming no trees whatsoever, and our results were that the noise was not an adverse impact. Therefore, the existence of any trees was not even considered because the wide open field scenario gave a no adverse impact result. I hope I'm answering the question you're
Yes,
asking.
you answered part of it. But as I recall, in the Chelsea study, it addressed, the expert opined as to the impact of tree loss on sound.
That's correct.
And that it was in, you know, the 2 to 5 decibel level. Was that considered in Apple Hill?
It wasn't, because the noise study in Chelsea that you're referring to was solely focused on the analysis of road noise being generated on Route 7 and traveling across our property. It looked at 2 scenarios. One where the current...
Trees and without trees.
With trees and
Right,
without
I'm
trees.
familiar with that, I guess.
Yep.
But was there a determination that because of the conclusions in the Chelsea study, that further study wasn't required at Apple Hill because of the minimal impact that tree loss had, as noted in the Chelsea study?
That is definitely correct, yes.
Okay. Those were all questions. Questions in light of the board's questions and answers. Is there any redirect?
Yes. Ms. Harris asked you some questions about the petitioner's interaction with the Bennington Select Board and the Bennington Planning Department. As part of the 248 petition process, did Apple Hill Solar contact the town of Bennington?
Yes.
And when was that?
I believe the first contact was October 2013.
Can you describe some of the subsequent interactions with the town of Bennington and its citizens on a formal basis?
Sure. On a formal basis, the town of Bennington received copies of the project's 45-day notice. I believe there were a couple different addresses at the town that received that. Accordingly, they also received a full copy of the project's 248 petition and all the company exhibits when that was filed. Is that what you're asking me, Michael?
And any time did the Bennington Select Board or the Bennington Planning Department invite the petitioner to come speak regarding the project?
No, we've not received any contact or questions from the town of Bennington.
Ms. Harris asked you a few things about the buffering effects of the trees. Were you at the site visit for Apple Hill?
Yes, I was.
And did Ms. Harris describe the existing wind conditions at her house?
Not at the site visit for Apple Hill. I believe that conversation took place at the site visit for Chelsea.
And at the site visit for Chelsea, how did she describe the existing wind conditions at her house?
I believe the term was like living in a wind tunnel.
And as part of the 248 process in this docket or in the Chelsea docket, did the petitioner ever have any consultations or interactions with wind experts?
Yes, as a result of informal conversations between Ms. Harris and I prior to her involvement as an intervener, we did reach out to investigate what it would take to perform the wind analysis that she was interested in.
And did those wind experts that you contacted, did they have any sort of opinion as to this type of project or this type of study that you would be asking them to perform?
Yes, almost uniformly, the anemometry consultants that we requested in giving us a cost and time frame to perform such modeling we had comments essentially to the effect of, for such a small piece of property, the results are probably going to be in the negative, that there is very little buffering effect. However, they caveat on that to say, you know, we're more than happy to charge you for a formal analysis.
I don't have any further questions.
Do any other parties have any further questions for Mr. Wilson?
No.
No.
I have one question. When we were here for the Chelsea hearing, you allowed me to get into the record an alternative noise study that we had found, which was totally different from the study that Mr. Wilson had simulated. It was the Federal Highway Transportation, and that was in the record. So is there any way for me to, in this docket, offer the whole study to you now again to show the...
So it sounds like what you want to do is you want to offer into evidence the Federal Highway Administration building standard noise study information that you provided in Chelsea, and you want to offer into evidence here as well. Is that correct?
Yes.
Is there any objection?
I think it's already in this docket through the testimony of Mr. Cow. It's attached as an exhibit.
Is it attached as an exhibit to his information?
It is.
Okay, so yes, you can, and yes, it will.
Thank you.
As long as it's not objected to in Mr.
I guess let's clarify. Can we clarify again the scope of his testimony? I want to make sure that that particular exhibit makes sense in light of restrictions.
I think that she can offer it outside of, it would not fit within the area of expertise of her expert witness. However, she can offer it separately, just as she did in Chelsea Solar.
I think if we're going to allow it into evidence in this docket, I need to be able to cross-examine somebody on the substance of what's in it.
Well, Mr. Towsley?
Just a second.
I'm sorry.
What do you mean the substance? It did not occur in Chelsea. It was offered as, okay, you can do that. I don't think you need Mr. Carroll to do it. I think she can offer it. She can discuss where it came from, and then you can make an objection if you think that's insufficient, and I would rule on that objection. Okay, Mr. Mapes, I'm sorry, Mr. Wilson, you may stand up. Thank you.
Thank you.
As I understand, there are no cross-examination questions for Mr. Mapes.
Correct.
Very well. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Can you proceed?
Can you please state your full name for the record
Scott Michael Mapes.
and your occupation?
I'm a professional engineer and a licensed attorney.
And you have in front of you your pre-filed testimony dated March 3rd, 2015, consisting of 15 pages, as well as petitioner's exhibits AHS SMM 1 through 6.
Yes, I do.
And were those prepared by you or under your direct supervision?
Yes, there were.
Are there any corrections to that testimony or to the attached exhibits at this time?
No.
And are they true and accurate to the best of your knowledge and belief?
Yes.
I'd like to move for the admission of the pre-filed testimony of Scott Michael Mapes, including all the attached exhibits thereto, which are exhibits A, H, S, SMM 1 through 6.
Is there any objection?
No.
No.
That was a negative from
No.
Ms. Harris? No? Very well. The pre-filed testimony of Scott Michael Mapes and exhibits Exhibit AHS SMM 1 through 6 are admitted into evidence. Do you wish to listen to any direct testimony? No, Mr. Mapes, you may sit down. Did you get, I think Mr. Wilson took a couple of exhibits from you when he was on the stand.
Oh, okay. So here's SNM.
Okay, now, Ms. Harris, we're up to Mr. Kitt, your opportunity to provide, to enter Mr. Carroll's testimony into the record, as well as do any direct examination you'd like to of Mr. Carroll, limited to the scope of his expert testimony as I described it earlier. Mr. Carroll, if you could take the chair, please. And you're reminded you're still under oath. You need a hand doing this, ma'am?
Mr. Carroll, do you have any corrections to your original testimony?
I do.
So I'd like to submit his pre-filed testimony and his corrections to his testimony.
Please. He needs to talk about what those corrections are, so that the parties are aware of what they are.
Okay, I mean, I have it here.
He has his copy. If anybody else.
I'll just go down to and read them off. That's the way you do it.
That works.
Answer 5, page 3, line 3. I would like to remove the word some. Answer 6, page 3.
Can we just, I want to make sure that we're doing this correctly. Answer 5, page 3.
I'd like to take the word
Okay.
some.
You want to add the word some?
Yeah, no, yes, not all. Answer 6, page 3, line 11. I'd like to change the 10, approximately 10 years ago, 7 acres for clear cut. I had that backwards. Answer 6, page 3, line 12, the same thing, 7, not 10. Answer 10, page 4, line 22. I'd like to remove that sentence. Answer 10, page 5, line 3, clear cut 7 acres, not 10. Answer 10, page 5, line 9, remove the sentence, in my experience, on the 400-acre parcel. Answer 12, page 6, line 5, clear cut, a swath, plus or minus 200 feet. I want to add plus or minus. Answer 14, page 6, line 22, remove the word tenfold and replace it with noticeably. Answer 14, page 7, line 2, remove the word when the bypass was completed and insert since the Welcome Center has been completed. Answer 20, page 8, line 5, remove in Bennington the police were called. Answer 20, page 8, line 10, remove, they are 30 foot tall and above, replace with they range in height to 30 feet. Answer 21, page 8, line 18. Remove the phrase Apple Hill. Answer 23, page 7, line 6. Add, but not all. Answer 24, page 9, line 11. Add just one simulated photo without vegetation, but with power lines. Answer 32, page 12, line 6. Remove higher and insert had. And that's it.
So the pre-filed testimony of Mr. Carroll, you already have, I believe.
Can I offer a second? Did he make the corrections on the hard copy?
No, he made them in this edition.
Okay, so he either has to make them or submit this as an
We'll submit the list of corrections as an exhibit. It's a separate exhibit. So this would be exhibit Harris 1, unless there's already one.
There is a,
You can decide what it's called.
LH1 is my sign notary.
LH2.
thank you.
Well, let me just ask the question, Mr. Carroll. With those corrections, is your pre-filed testimony truly best to your knowledge and ability? Yes.
So I'd like to offer as exhibits, Exhibit LHRC1, resume of Richard Carroll, and the wind data and the noise data, I'd like to make exhibits separately as my own. And 4 and 5, which is Highway Traffic Noise Barrier Design Handbook, and the photographs, the actual photographs and videos that I took of the Welcome Center and the monument.
Okay. Have the other parties had an opportunity to examine these exhibits?
They were part of Mr. Carroll's pre-filed testimony,
Very
which
well.
we're now
I
separating
understand.
out.
I understand. So right now you have your first exhibit, which was the affidavit. You have the second exhibit, which was the list of corrections of Mr. Carroll's pre-filed testimony. What's LH3?
LH2 was my wind data, so maybe that had this. Oh, that you have already as part to be separated out. And then LHRC3 was the noise data, and was that from my phone? Am I allowed to offer that separately as my own? The app that I had for the actual noise representation at my house?
You can offer it. Whether it will be admitted is another question.
Okay, then may I offer that?
What is it?
I put an app on my phone which is called Decibel 10th dB, and it's an app that measures the noise level at any time of day or night at a site.
Do you have a document that describes its technical features?
Not with me, but it's readily available.
Then I'm not going to admit it.
Okay. Okay. Then I'd like to put put as an exhibit the FHWA Highway Traffic Noise Barrier Design Handbook.
Okay, so let's get back to the beginning. You have LH1, which is the affidavit, LH2, which is the correction of Mr. Carroll's testimony. What's 3? They were already labeled as something different, okay.
So exhibit LHRC1 is Mr. Carroll's resume.
Oh, okay.
Exhibit LHRC2 is the wind data study from NOAA. The exhibit, the noise data I can't offer, so exhibit LHRC4 is the FHWA Highway Traffic Noise Barrier Design Handbook. And the exhibit LHRC5 is the photographs and videos. Which are part of it as well. But they were,
You want to do them separately, but those are all part of it.
they were all part of Mr. Carroll's pre-filed testimony, except now I'm separating them out as my own,
Except for his resume.
except for his resume.
So the only one I object to is the FHA guidebook, again, because I guess I need to better understand. I have several questions about that guidebook and the data that it's based on. Most of the questions already went out to Ms. Harris through discovery, but I didn't get responses. So I'm just wondering who I'm going to have on the stand that I can cross-examine with respect to that data.
I'm going to overrule your objection and accept that document and give it the way that that's appropriate. Having heard that, what I have now marked are the 7 exhibits of Ms. Harris are entered into evidence. Oh, that's right. It's, there are 6 exhibits. So LH1, LH2, LH4, LH5, LH6, and LH7, at least as I have marked them. Okay. Ms. Harris, do you have questions on direct that are within the scope that you'd like to ask Mr. Carroll? And you really don't want to necessarily, you don't need to be repetitive of previous testimony that he's provided.
No, I'll just open him up to
Cross-examination.
cross-examination.
Very well.
That should be pre-filed, absolutely.
Okay, and the pre-file has been entered into evidence. As corrected.
Mr. Gower, you've gone on the record saying that.
Let me just limit this for a second.
Yep.
You know, there are questions and answers on the record related to the quality of his expertise. I would ask that you not repeat any of those same questions and answers. Or same questions to yield the same answers.
My question was, you stated that you haven't read the entirety of the testimony, and I think you just corrected your pre-filed testimony to reflect that. Having not read the entire testimony, including certain aspects of our mitigation plan, do you feel, are there any other changes that you want to make to your pre-filed testimony?
No, I've read this whole testimony, my pre-file testimony.
Let me rephrase the question. Have you read all of Mark Kane's testimony as to aesthetics?
No.
So, in your pre-filed testimony, you make some conclusions based on our aesthetic plan. Are all of those conclusions still accurate?
No, they were confusing. There was, when I tried to find the photograph of the power lines and the one that I presented to the town board, there were some things in there that were a little confusing. And can't say exactly what it was a little confusing, because I just don't get that information from you or from the board.
So not having received or not having read the petitioner's aesthetic plans, you feel that you are qualified to give an opinion as an expert on the aesthetic effect of this project?
From what I was given, yes. For what I have, yes.
And you acknowledge that what you have been given is not the whole picture as to the mitigation plan of the petition?
That's right.
In your testimony, you mentioned in the answer to question 10, A10, it's without a question that the effects of the winds will increase. Is there any scientific evidence to support that conclusion?
It's just, there's nothing scientific about it. I've walked that property, and it's just, it's natural. That's what's going to happen when you take out 27 acres.
Is it your opinion that the trees that are in question in this docket are providing a wind buffer?
Yes.
And in your testimony, this is in answer 10, you state that trees that are growing there now, the taller trees aren't used to the winds being higher and they will knock over trees. That is what happened on my 21 acres of land when they clear cut 10 acres on the other side of me. To get a better understanding of what you mean by that, are you saying that neighboring trees are going to be coming down because of the clear cut?
If you clear cut 27 acres and the wind comes through, any trees that are forward of that 21 acres have the potential to fall. That's what happened on my 21 acres.
And so there's an existing tree line that kind of follows Route 7 from the south and along the western border. There's no trees that are currently buffering that perimeter, those trees that are just on the line of the perimeter. How do you explain those trees being able to stand when there's no buffer?
It's probably all new growth. I mean, those trees right there grew in the wind. And what I'm talking about is if you take 27 acres out, away, anything that's in front of those has the potential to fall. They're not used to the wind. The trees you're talking about are.
And while you were on the stand earlier, you mentioned that part of the issue of this neighborhood are winds coming in from the west. Is that correct?
In regards to what?
In regards to the current effects being felt by Ms. Harris at her house.
They do. They come from the west, southwest.
Do you understand that in this docket, none of the trees to the west of Ms. Harris's property are proposed to be cut?
Well, the wind comes from there. It also comes from the Welcoming Center, which is southwest. I think that's what I had there.
In your testimony, you mentioned the clear cutting that was done by Velco, I believe.
Yes.
What year was that?
I think that was 2011.
And was Velco required to do any mitigation on that site because of the clear cutting?
They did.
And do you understand or do you know what the cost of that mitigation was to Velco?
I believe it was 5,000.
And do you understand the scope or the expense of the petitioner in this docket is spending on mitigation?
No, I don't. I've never received that information.
As part of your testimony, which was actually just corrected, you mentioned that the completion of the Welcome Center resulted in an increase in noise. I think you changed it from tenfold to something else. I'm trying to get a better understanding of how you reached that conclusion. At any time did you actually measure the noise, either before or after the construction of the Welcome Center?
After it was completed, how do I know the sound increased?
Did you measure the noise at the Welcome Center or near the Welcome Center prior to construction?
I didn't measure it at all. I could hear traffic going up and down.
And did you measure it after construction at all?
No, I could hear the increase.
In general, would you describe the Apple Hill neighborhood as being quiet or noisy or somewhere in between?
The Apple Hill right now is somewhere in between. And that obviously we're concerned about the increase in noise.
And what about the wind in the neighborhood? Ms. Harris has often described fierce winds or living in a wind tunnel. Is that accurate?
It's windy at her house. She is definitely, right now, the most exposed along with a number of other people there. And the only thing that buffers her property at this point, when the winds come from the Welcoming Center, is that 27 acres.
I don't have any further questions.
Is there any other parties that have questions across?
No.
No. Is there a
May I?
redirect? Do you have a redirect?
Yes.
It would be based on questions that were asked in cross.
Yes.
Okay, go ahead.
Yes, thank you. So, you say you didn't actually scientifically measure the difference in the winds before and after the Welcome Center was put up, but so are you saying that you're basing your expert testimony on your experience of witnessing day to day the changes?
I'm basing that experience on what I feel when I walk Willow Road. It's a path that is used by a lot of people, especially me, when we walk our dogs. And when the wind comes up over from the Welcoming Center, that's where you visually see the snow just drives right through there. And the first thing that it hits is the 27 acres. One of the things in the past 20 years, when you walk through there, and it's in the wintertime and the winds are there, you kind of hurry through that area until you get into the wooded area we're talking about, clear cutting. That's my experience with that for 18 years.
So, to summarize, would you say that the testimony you've offered is reliable and relevant in an experiential way to honor your status as an expert?
Yes.
That's all I have.
Any other cross? Any questions, Mr. Carroll, you may stand up. Thank you very much. Do you have any other evidence to seek admission of? Great. I've been looking for where I wrote down the schedule, and I can't find it. If someone could help me refresh my recollection. I knew it was in September. When do the briefs due?
The 10th?
September 10th, and rebuttal briefs,
The 17th.
September 17th, and the draft proposal for decision was September 25th, is that correct? This has been a longer afternoon. I appreciate everybody's efforts and patience throughout the process. Do we have any other business to take up before closing? I see a lot of head shaking negative uniformly from the parties.
No.
I say that for the record. Therefore, this hearing is adjourned. Thank you very much.